Loading. Just wait.
Page number 1. 1 to 8. Page number 2. 9 to 22. Page number 3. 23 to 52. Page number 4. 34 to 45. 5. 42 to 43. Page number 6. 44 to 51.
Weeks time granted. Yes. Compliance. Is the matter on? Okay.
Page number 7. 52 to 55. Page number 8. 56 to 55. Page number 9. 8 to 71.
12:30. 12:30. 12:30. Yeah. Manjunath.
Serial number 2.
Password. Password. Yes. Commercial taxes. M. Kumar. AG accepts notice for respondent 1 and 2. Now, what is the legal position? Yes. What is the legal position? So this is that IBC coding. Huh? Take notice. Next week. Next week. Appealable under section. Good. Good. And so you get instruction. You'll have it next week. That's the matter. In the orders list. On date 15th.
5.
Pass over.
6.
Take out notes. AG accepts notice for respondents. 1, 2, 3. Consideration of interim prayer is kept open. List the matter on 15. Next week. Yes. No. 31st March. What is the order passed in similar matters?
The branch manager Vijaya Hydro Bank of Baroda.
So this was issued under the unamended 148. Same, and then that group also you get it up sometime. That group, you get it up someday. Let's. He's coming, I think, on 20 some date. Some date he's coming. You find out. Huh? Yes. The counsel for the petitioner has assailed the notice under 148 and the assessment order passed under 147 read with 144. Petitioners also challenged the computation sheet, the notice of demand, penalty notice. Petitioner, counsel for the petitioner submits that notice under 148, under the unamended provision of 148 was issued, and subsequently proceedings have continued, though by virtue of the introduction of the amended 148 on 1/4/2021, the proceedings would not have continued. Attention is drawn to the order passed under a similar factual matrix relating to the identical legal question, copy of which is produced at annexure in WP 8430 of 2022, which reads as follows. Accordingly, in the present matter also, there would be an interim order staying E1 to E3 F and G. Third Council Sri Sanmati accepts notice for respondents. 1 to 3. Statement of objections. Directed to take notice. Directed to take notice for respondents. 1 to 3. Statement of objections to be filed. Copies to be served on council for the respondent. This is the matter after 2 weeks. That's why we should be careful in the terminology we use. Finally, it's only the record that speaks. Yes. Soft copies to be served. Yes. Last week. Next week. Yes. The council should delete steps notice for respondent 1 and 2. This is the matter in the preliminary hearing list on 15th. Copies to be served. Yes.
It's either a requirement of lesser accident, in this case, facts are the SST was incorporated.
Hey, Arvind, one matter, that 197, that was one matter you had appeared. 197 that time. 195. Okay. Yes.
Even the SST was incorporated, and it actually covers the nature as it is built quite for the two entities set their investment funds. Different business fund. 2023 was the first financial year that actually certain transactions. Year 2023 was the first. Because it's just a company that just incorporated as the process the earlier. And the application was made in the earlier year also for reduction of tax. It's actually not rejected. I filed an application on the record or revision by commissioner. That order I did not challenge because that order came towards the end of the last financial year. There was no use for me because by then the entire financial year, all the business that I received after tax, there was no point in challenging that order. Therefore, I made another application for this year in January, saying that I will continue my estimated income is negative, and I continue to keep the process this year as well. There is no taxable income. Therefore, there is no requirement to deduct tax. Please give me a certificate directing my payments or deduct tax. The revenue officer rejects this application on not kindly see the EP order. Next D. Page 44. The requirements keep eating. Not applied.
Yes.
Also satisfied. And our total income which requires tax deduction. Yes, so it is my application that I online is and if you require something, requires tax deduction. What 197 says. 197 2 years says that the more rate outside
Yes. estimated income of this relevant tax. I have another my estimated tax for this case. I have another about $100 cost. Then can you see tax payable to the assessed or return or estimated income as is maybe or last 4 years. Now this clause I cannot satisfy because I was not in business for last 4 years. Now the assessment officer that is one of this clause says I can do not apply with code 28A and therefore I will not issue the certificate. This point number has been considered by the Bombay High Court. Bombay High Court only says that 28A is only a guideline. The guideline is only a guideline. Otherwise, what happens for any new company is cannot file an application. As section 197, you can only file it in the 6th year of its operation. Until 5 years, it cannot file an application. Not the guidance in this Bombay High Court.
The person, the mechanism under 258 is paid. The case of the SC for the financial statements of the SC for the is the career of are available. SC had brought to the notice of SC council the circumstance that during the financial year change, it had not done any revenue for the project. And necessarily had because of the fact that the project was awarded. Which follow thereafter provide a mode of computing the rate at which the tax is to be deducted. So, suppose one refers something advanced tax already paid and the tax break down the case of that is provided is resident for eligible. If the SC officer says I am not satisfied that comes through, and therefore I am not entitled for that. That is the first reason. The second reason given by the SC officer is that in another group entities case there are 2 or more proceedings that are pending and there is a stay by this court. Therefore, I cannot be. Including our how is that connected with my application for other 197? Assuming there is liability is cost rate of the group entity. Collected from the original land unless
Yes, look into it. Except notice to be responded. Is the matter on? What is the date? Let him file his objection.
Assessment is complicated. Most of these are starting the department and I don't get it.
No. Now let's now in the event that 28 AA upon instruction you file your objection. If it were to come to a conclusion that those are only guidelines as the Bombay High Court held, which appears to be prima facie correct, anyhow, you get back. Then the matter could be directed to be relooked. You find 2 weeks. Let us. Yeah. That council KV accepts notice from the respondent. This is the matter in the preliminary hearing list on week after this, 22nd. the preliminary hearing. Yes. It has to constitute. Yes. Commissioner Central Tax. Where Council G1 immediately accepts notice for the respondent. Consideration of interim prayer is kept open. List the matter on 22nd in the orders list. Consideration of interim prayer is kept open. Mayor Council Shri Sushal Tiwari accepts notice for the respondents. So we'll have it next week. Let him get instruction. Wednesday. Let us see. They're seeking for some interim order. Preliminary, at least you have it. Consideration of interim prayer is kept open. This is the matter in the orders list on 14. The petitioner to serve copies to the respondent, including soft copy. 12, 13, 14 are same. What did we do yesterday? No orders passed. Mayor Council Sushal Tiwari accepts notice for the respondent. This is the matter on 21st. Along with them. So this all the three matters. 12, 13, 14. What is that interim order that we have passed? There would be now interim stay of interim stay of annexure A1 to A4. Same order. At annexure Q3, page 227. passed in WP 10330/2020. Land Council Shri Tushar Tiwari, Sushal Tiwari accepts notice for the respondents. All respondents.
May it please. Worships, I appear, Manoj, for the petitioners in serial number 16, Manoj. May it please,
Yes.
Manoj. Manoj,
Yes.
this is a classic case, Manoj, where what cannot be done directly, Manoj, is sought to be done indirectly, Manoj. Manoj, I am an exporter of goods, Manoj. The lordships are aware, Manoj, export is 0 rated. I am entitled to a refund of my unutilized credit. Manoj,
Just one minute. Commissioner of Central Tax, then Union of India, Third Council Shri Madan Mohan Pillai accepts notice for the first respondent. Third Council Jeevan accepts notice for the second respondent. You can just handle.
they've been solved, Manoj. I've been informed.
But always, when you come seeking interim player, etc., you must have an extra set. So, you must not rub. You must not correct. You must not rub the government advocate on the wrong side when you have higher stakes. That's okay. Yes. Yes.
Please,
Yes.
Manoj. Now, Manoj, the issue is, Manoj, that I applied, Manoj, for a refund. I gave all the evidence, Manoj. There was then a show cause notice issued, Manoj. I filed a reply, and after a detailed consideration and satisfaction, the refund was allowed to me and also disbursed. Manoj, this is a statutory order passed under section 54(5) of the GST Act. Now, Manoj, against this order, Manoj, the limited jurisdiction that the department has is, Manoj, that the commissioner, Manoj, under 107(2) can review the legality or the propriety of this order and then direct the same officer to file an appeal. Now, Manoj, the department does not do so. These refund orders have attained finality. After 2.5 years, Manoj, they now issue me a show cause notice saying these refunds are erroneously granted. Now, my lords, that issue, my lords, with respect, is no longer res integra. The Supreme Court and, my lords, consistently the High Courts have said, once the refund is granted by adjudication, the proper course is to challenge that order. It cannot be said that the refund is erroneously granted. Now, my lords, on that, I have just one decision, my lords, for my lords' consideration, which my colleague is carrying, my lords. And before that, my lords, I will just show that order which sanctions the refund, which is, my lords, at Annexure J at 111.
You just take me to the relevant provisions.
Please, my lords. My lords, if Lordships, my lords, has the Bear Act, my lords, and
Yes.
my lords may have section 54, which is, my lords, the provision under which, my lords, a refund is applied, 54 subsection 1 of the CGST Act.
Yes.
If my lords has 54(1), my lords, this is the section under which a person claiming refund, my lords, is required to make an application. My lords has 54(1), my lords.
Yes.
May I read?
Yes.
Any person claiming refund of any tax and interest, if any, paid on such tax or any other amount paid by him may make an application before expiry of 2 years from the relevant date. And my lords will see, my lords, 54 subsection 4, what this has to be accompanied with. My lords, this has to be accompanied with documentary evidence as prescribed to establish that the refund is due. And thereafter, my lords, after consideration under 54(5), an order is passed, my lords, which is, my lords, if on receipt of such application, the proper officer is satisfied that the whole or part of the amount claimed as refund is refundable, he may make an order accordingly, and the amount so determined shall be credited to the fund referred to in section 57. My lords, this is a case of if there is unjust enrichment. Now, my lords,
Yes.
there is a corresponding rule, my lords, which is rule 90, my lords, which is the corresponding rule to section 54. Rule 90 is,
Yes.
my lords,
Yes.
has it, my lords. And my lords, in this rule, my lords, lordships may have rule 92, which is the order sanctioning refund. Rule 92.
Yes.
My lords, 92 1 says, where upon examination of the application, the proper officer is satisfied that a refund under 54(5) is due and payable, he shall make an order in GST RFD 06 sanctioning the payment. Now, my
Yes.
lords, this background, my lords, kindly for a moment, my lords, also see 107. My lords, 107, which is, my lords, the appellate provision, and 107(2) is relevant, my lords.
Yes.
My lords, 107(2), if I may, my lords, 107(1), I will read, my lords. This says, any person aggrieved by any decision or order under this act. My lords, 54(5) is also that decision.
So it includes the revenue.
It includes the revenue, and my lords, kindly have 107(2), which is relevant in this case.
இந்த கேஸ் சீரியல் நம்பர் 10 ன்றண்டி இப்போ எந்த கேஸ் போறதுன்னு
107(2), my lords, I'm sorry, my lords. 107(2) says the commissioner may, on his own motion or upon request from the commissioner of state or center, call for and examine the record of any proceeding in which an adjudicating authority has passed any decision under the State GST Act or UT GST Act for the purposes of satisfying himself as to the legality or propriety of the said decision, and may by order direct any officer subordinate to him to apply to the appellate authority within 6 months from the date of communication or the order of determination as may be specified. So therefore, my lords, after passing 54(5), it is only under 107(2) that a jurisdiction is vested, that there can be, my lords, a limited review, and pursuant thereto, my lords, the same authority which has granted the refund can file for an appeal. Now, my lords, that admittedly is not done in this case. Now, my lords, with this background, kindly have, my lords, page 111, which is Annexure J. My lords may have. My lords, at 111, my lords will recall, my lords, the form it says is GST RFD 06. And my lords, I had shown to my lords rule 92(1). This is the form in which the order under 54(5) is passed.
Yes.
Now, my lords, may kindly see, my lords, the facts are given, my lords. Thereafter,
So now the notice is issued without there being an order under 107(2).
please, my lords, they have not filed an appeal against this order. And now, my lords, what I receive, my lords, is, lordships may kindly see, is at page 118, which is a show cause notice. And the relevant part, my lords, is at 121, Annexure M. They let this order attain finality. This is not disturbed. Then from the very same officer, I mean, the same commissionerate, I received this show cause notice under 121. And my lords will see, my lords, your lordships will have page 123, 7A, they invoke, my lords, 73(1) of the Act. My lords, has it, my lords, at page 123.
Yes.
They say an amount of so and so being an excessive refund should not be demanded. Now, my lords, 73(1), your lordships may kindly have the bare act again. 73(1), my lords, is a provision in which, my lords, a show cause can be issued, my lords, for a short levy or a non-levy, my lords, or, my lords, for a erroneous refund. My lords, I'll read that, 73(1), where it appears to the proper officer that
So you're saying that the erroneous refund has to be adjudicated upon.
well, that has been adjudicated in my case. The order
No,
was
the-
passed. That has to be challenged under 107(2).
No, you're saying 73 to operate, that
Please,
erroneous refund has to be adjudicated in terms of 107. Without recourse to that, you cannot have recourse to 73.
Or my lords, 107 or 73 applies in a case where there is no adjudication. There is a prima facie provisional refund granted, which is without an application, and thereafter it appears to the authority that that is erroneously granted. What, my lords, the Supreme Court has held that a case of an adjudication of refund is different from a mechanical act of sanctioning a refund. In case of mechanical acts of sanctioning, 73 can apply if there is no application of mind. Whereas if there is a proper order passed, which is under 54(5), and my lords, in that case, what was analyzed were pari materia provisions of the Excise Act, which remain exactly the same as 54. They said upon adjudication, the same officer cannot now invoke 73(1) because that would result, my lords, in defeating one, the right of the assessee to appeal against the order of the refund. If the refund would have been rejected, he could have appealed. Second, that order attains finality, and that is, my lords, an order which is passed by a quasi-judicial authority. And my lords, that is exactly what, my lords, has been reiterated. And there is one judgment, if my lords can see, my lords, which is my colleague will hand over, my lords. This is Ever Ready Industries, the Madras High Court, in which, my lords, that Supreme Court is also mentioned, my lords. And my lords may kindly have this is the Madras High Court, my lords. Justice Ramasubramaniam, my lords, authoring. My lords, lordships may have page 2 of 8, where para 4 is, my lords, the question of law. My lords, has it, my lords, may I read? My lords, it says, whether the first respondent is right in holding that there can be a demand notice under 11A of the Excise Act. My lords, with respect, this is paramateria to 73(1), which my lords read, by the original authority for alleged erroneous refund, earlier granted by the same original authority without reviewing at all the refund order of the original authority by the superior authority in terms of 35E. With respect, my lords, 35E now is 107(2). My lords, this is the question. Now, my lords, lordships may straight away come, my lords, to the relevant findings, my lords. Which, my lords, first, my lords, I will show, my lords, at page 3 of 8, my lords, section 11A, which is at para 12. And my lords, page 3 of 8, my lords.
Yes.
Para 12. What is 11A, my lords? 11A, your lordships will see, when a duty of excise has not been levied or paid, or has been short levied or short paid, or erroneously refunded. My lords, pari materia provision, which, my lords, is as per 73(1). And my lords now have, my lords, 35E, which is at page 4 of 8, para 14, which is, my lords, pari materia to 107(2). My lords, it says, the board, my lords, and the second one, lordships may have 35E2, which is pari materia. The commissioner, on his own motion, may call for and examine the record of any proceeding in which an adjudicating authority subordinate to him has passed an order, and for the purposes of satisfying himself as to the legality or propriety, by order direct such authority to apply to the commissioner appeals for determination. My lords, similar to 107(2). And now, my lords, may kindly see, my lords, para 15, my lords. It says, as could be seen from 35E2, the Commissioner of Central Excise has a suo motu power of revision to call for and examine the record of any proceeding in which an adjudicating authority subordinate to him has passed a decision for the purposes of satisfying himself to the legality or propriety. Interestingly, the power of revision is not a normal power of revision under which the revisional authority could by itself correct the error on part of the subordinate officer. The power available is a limited power and extends only to a direction to such authority. And, my lords, may kindly now have, my lords, what is relevant, my lords, is page 5 of 8, para 28. My lords, it says, may I read, my lords? But a careful look at the sections 11A, 11B, and 35E would show that an application for refund is not to be dealt with merely as a ministerial act or an administrative act. Under 11B, a person claiming a refund of duty and interest should make an application in the prescribed form. Such application must be within limitation, must be accompanied by evidence, and thereafter 11B2 mandates that the officer should be satisfied that the duty is refundable and should make an order. The refund is capable of being given effect by subsequent search. That is not relevant. Now, my lords, kindly have, my lords, what is, my lords, important now is, my lords, para, page 7 of 8, para 46. My lords, it says, in this case, an order of refund was passed on an application under 11B. The appeal against the finalization of the assessment was closed on the basis of the refund order. There can be no doubt about the fact that the statutory right of appeal is a valuable right conferred upon the assessee. That right was actually altered on the basis of the order of refund. Suppose there had been no order of refund, the appeal could have been pursued against the finalization. In other words, two valuable rights, one in the form of a right of appeal and another in the form of an order of refund, are now sought to be taken away indirectly by taking recourse of 11A. What cannot be done directly cannot be done by indirectly also. And now, my lords, kindly have para 50, where, my lords, the Supreme Court decision is reiterated. The very same argument now advanced by the department to the effect of 11A and 35E operate in two different independent fields were raised by them. After considering the issue elaborately and after taking note of the decision of Asian Paints as approved by the Supreme Court, paragraph 23 is as follows. In our opinion, there is no nexus between 11A and 35E. 11A does not indicate that the legislature intended to override 35E. Both the sections have to be read harmoniously. In the present case, Annexure I certificate has been issued in the favor of petitioners from time to time on executing a bond and on furnishing a bank guarantee. The department has to follow the procedure under 35E for setting aside annexure certificate. Unless it is cancelled or rejected by following the provision of 35E, it is not permissible to invoke 11A. And, my lords, 51 is the operative part. We are of the considered view that the paragraph extracted above is a complete answer to the question of law framed. Unfortunately, none of the decisions relied upon by the standing councils, the courts were confronted with an order of adjudication under 11B on an application. Once an application for refund is allowed under 11B, the expression erroneous refund appearing under 11A1 cannot be applied. If an order of refund is passed after adjudication, the amount refunded will not qualify under the category of erroneous refund, and 11A cannot be invoked. My lords, with respect, my lords, that's, my lords, the answer to your lordship's query, my lords, that if this order is passed, my lords, after an application filed, and, my lords, in my case, there is a show cause notice, I have filed a detailed reply. And thereafter, my lords, there is an adjudication, and after that, there is a dispersal also. Now, my lords, having done all of that, my lords, the show cause notice cannot be issued under 73(1), thereby bypassing, my lords, 107(2). My lords, that's the short legal point, my lords. Therefore, my lords, the order is inherently without jurisdiction. And also, my lords, please.
Just use the mic. Use the mic.
Cannot hear my learned friend.
Mic adjust. So the sound.
I can refer to my lord the para 36 of that.
So now if the point that he's raising is that if there is a order of refund after adjudication and consideration, and unless that is set aside in terms of the procedure under 107, you cannot take recourse to 73.
That's a contention, that I am disputing it.
That 73, what would be only prima facie and cannot be pressed into service where a substantive adjudication has taken place, consequent to which refund is made. That's their contention.
But by reading of 73 doesn't indicate any such allowed that.
Okay.
Because you are reading an application for a refund, and there has to be a refund order. That can't be, my lord, if merely by asking, my lord, no one grants it. The procedure is there.
Correct. Now,
And he has to satisfy certain conditions, my lord, know that, my lord, he is eligible for refund. My lord, authority is bound to consider all those.
now you
There
take,
can't be any automatic refund, my lord, as soon as they file the order.
that is there. But suppose, now of course, you have a look at the refund order and the adjudication.
For consideration, my lord, what
Have it.
point he writes, what require consideration.
The granted limited interim order, in the next date you file your objection. The learned counsel for the petitioner would submit that the refund has been granted pursuant to adjudication in terms of 54(5).
54.5, my lords. Section 54.5.
It is submitted that without that order of refund upon adjudication having been challenged by taking recourse under 107(2) by the authorities in the manner prescribed, recourse to 73, isn't it?
Please, my lord, 73 subsection 1.
73(1) does not arise. Matter requires consideration. In the interregnum, there would be a stay of
My lords, annexure, my lords, A, which is the impugned order dated 3rd February 2023.
now stay of which order now?
My lords, now, my lords, the original.
Show cause.
No, my lords, pursuant to the show cause notice, my lords, there was a order in original past. Thereafter, my lords, I preferred a first appeal, and an order in appeal is passed. Now, my lords, your lordships are aware the tribunal has not been constituted, my lords. So therefore,
interim order of stay of the order at annexure A and proceedings pursuant thereto.
please, my lords.
Interim order would be enforced till the next date. Respondents are at liberty to seek for modification of the interim order if circumstances are so made out upon filing statement of objections. This is the matter after 2 weeks. Notice ಮುಂಚೆನೇ ಇರ್ಬೇಕು. Learned counsel Shri Madan Mohan Pillai accepts notice of first respondent. Learned counsel Jeevan accepts notice for the second respondent.
Both 107 is best. 107. No question of coming back to 170. Because 107 is an appeal provision. Appellate order only finds from the subordinate authority to be enforced.
Let us see, but
No question of without removing 107, I don't think that's correct or wrong. That question may not arise.
let us see whether there is any class of cases without adjudication. Still, you may go under 73. If prima facie there is some mistake. I don't know. Have a look at it.
My lords, I'm grateful, my lords, deeply obliged.
ಅದಿಲ್ವಾ? Yes. Just only. Then IA for dispensation. 16. 16 IA for dispensation. Dispensed. Yes. The same thing. AGA accepts notice for respondents 1 to 3. They have served copies. Want it next week? Let us see. 30 days time is there. Next. When that time is there, we'll see. This is the matter in the orders list on 22nd. Consideration of interim place kept. What was the challenge initially? Now, reassessment order is passed. But you'll have to challenge this independently. Now, there was no interim order, order is passed already. Now, substantive remedy available against this order, you'll have to take it up. Not in this, we don't know what the grounds that have been raised in the assessment order. You can challenge that separately. Challenge the validity of the order passed. You can withdraw all contentions kept open, liberty to reserve to challenge the assessment order. The Learned Council for the Revenue will point out that an assessment order has been passed on 31/3/22. On 31/3/22. When was this writ filed? Date of filing. 20. In the year. find that the present writ petition, as there was no interim order, assessment order itself was passed. In light of the same, the leave sought for requires to be reworked afresh. Accordingly, the petition is disposed of, reserving liberty to the petitioner to challenge the assessment order dated 31/3/2022 in accordance with law. All contentions raised in the present petition are kept open to be raised in a subsequent attack to the assessment order. Accordingly, petition is disposed of. Counsel for the Revenue files a memo along with copy of assessment order. Same is taken on record. Serial number? Yes. Take me through the relevant facts. Yes. Exactly. Yes. Yes.
So far as should be on a police picture, either they decide for us or it is regarded. But I didn't say they capital gain. It has already been decided that the original because they cannot move there. How to go back to regular. So it's came up for concentration because the experiment of how to go. And they want to go. That one of the Supreme Court also. So they decided it. They want to the market from in fact, that is the Maybe go to the general bank after the judgment of various court.
Yeah, you are not. Yes, yes. Yes.
Long-term capital gain on now, if they want to stay at home, then they have some clothing. There are some activity masks that the satisfy that people have.
Let us see now this aspect will specify, let him consider. What are these 6 matters? Oh, but these are for
Four matters for all. Very important. Very important.
same assessment here.
Same such.
Common order can be passed. The petitioners.
Hello. Sir, I'm Raman from Wipro actually.
For 19 called along with 20, 21 and 22 and disposed of by a common order as SSCs belong to the same HUL. Same HUL. As the SSCs are a part of the same HUL. Petitions are taken up together and disposed of by common order in light of a similar factual matrix. The petitioners have challenged the penalty order at annexure H2 for the assessment year 17-18 and have also sought for setting aside of the assessment order dated 18/3/2022 at annexure C. It is the contention of Senior Counsel Sri Anil Sheshachala appearing for the petitioners. That the impugned orders passed, including the penalty order at 27A, is without affording mandatory hearing in terms of the legal requirement under 274(1) of the Act, and also insofar as the assessment order passed under Section 143, subclause 3, right with Section 153C of the Income Tax Act. Opportunity of hearing, as is provided for under Section 143(3) of the IT Act, was not given. It is also contended that the authority had no jurisdiction to invoke Section 153C of the Income Tax Act. It is pointed out that while that for the purpose of initiating proceedings, there must be recovery of incriminatory material, without which recourse cannot be had to Section 153C, and that the only option available in such circumstance would be to proceed for reassessment under 147/148. Reliance is placed on the judgment in the case of Principal Commissioner of Income Tax versus Abhisar Buildwell Private Limited, 2023 SEC Online, Supreme Court 481. Next. Taking note that admittedly there has been a violation of principles of natural justice. Case is made out for remanding the matter for fresh consideration by directing the authority, while embarking upon such consideration, to specifically advert to the contention raised regarding 153C, including to the law laid down by the Apex Court in the case of PCIT versus Abhisar Buildwell Private Limited. Accordingly, the petition is allowed. The order the assessment order. There are different annexures. The assessment order is one purpose. Annexure C and the penalty order at annexure H2 are set aside. The authority to reconsider the matter in light of the discussion made above, including the contentions raised by the petitioner, as noticed. Respondent is directed to fix a date for hearing and afford opportunity of personal hearing as mandated under law as noticed above, and pass fresh orders. So now, which of these SSCs? You just just make a table with the petitioner number, writ petition, and annexures. We'll just separate orders we can pass, but anyhow we make the table and yes. Yes. Central tax. Who appears? Jivan. You pass over, let him. As soon as he comes, you make a mention, I'll take it up. Pass over.
Your Lordship, appearing for the petitioner, Your Lordship.
Yes.
Your Lordship, this issue is pertaining to the reopening initiated by the assessing officer, Your Lordship. The assessing officer had not served the notices under 148A-B as well as notices under section 148A-D on the petitioner itself, Your Lordship. The assessing officer has uploaded the notices in the portal by entering the email ID of the petitioner as no email ID at abc.com, Your Lordship.
Where do you get that reference?
Your Lordship, that is in the, I have enclosed the status, Your Lordship. If Your Lordship,
Just one minute. Yes.
if Your Lordships could take to Annexure D, page 37, Your Lordship.
Yes.
This intimation, if Your Lordships could see at page 37, the communication has been sent to no email ID at abc.com, Your Lordship.
Yes.
Prior to that, Your Lordship, the notices under 148A as well as 148AD were not served on the petitioner itself, Your Lordship. Even at Annexure B at page 32, Your Lordship, which is with regard to the notice under 148, it was served to the same email ID which is there at page number 37, Your Lordship.
Yes.
Page 32, Your Lordship.
Yes.
The petitioner was not served with any of the notices, Your Lordship, except the notice under section 142(1) on 20th January 2023, which is at Annexure E, Your Lordship. That was sent by post, Your Lordship. They uploaded this notice at Annexure E on the portal, and they also sent a physical post to the assessee, Your Lordship, with the wrong information, Your Lordship. They have said that I have sold a property to some person by name Oblesh for a consideration of 1 crore, Your Lordship. That is at page number 42, Your Lordship. Annexure.
Yes.
Transaction entered into sale consideration received on sale of property. Sale consideration of immovable property, Kasturi Oblesh, amount paid or credited 1 crore, Your Lordship.
Yes.
That is, in fact, I have not entered into any transaction with such person, Your Lordship. Thereafter, I uploaded my detail. I registered myself on the portal and I gave my reply say to the officer, which is at annexure F at page 45, Your Lordship.
Yes.
I stated that I have not sold any property to Mr. Kasturi Oblesh. Therefore, there is no transaction with me. If I can read, Your Lordship, in the he said,
Just 1 minute. Just 1 minute.
When the assessment order has been passed, annexure J, page number 55. After considering the reply filed by the assessee at page number 51, Milord, annexure H. H is the reply, Milord.
But this is the reply to which one? 142.
Yes, no, 148 notice, and he has contested the main.
Your Lordship,
Order under section 147, 144. Where judgment assessment has been passed, Milord. The appeal authority has recorded reasons that paragraph number 67. He has stated that as far as the additions concerned, the assessor has not given supporting evidences. Page number 57, Milord. The assessment order. Now the final assessment order has been passed, Milord, on considering the decree. Annexure J is the final order.
But now a final assessment order is passed.
yes, Your Lordship, but the notices under 148 were not served upon me, Your Lordship. There was no service of notice on me, Your Lordship. And the information which was seen in the notice which the assessing officer initially proceeded was on a different issue, as well as in the assessment proceedings. When he served the 142 notice, he issued a notice saying that I have sold a property for 1 crore. The assessee was not knowing what was the information with the assessing officer to reopen, Your Lordship. And moreover, the assessing officer dismisses my does not consider my my submissions just because I have not filed the front page of the bank passbook, Your Lordship.
Where do you get that? Where do you get that?
Yes, Your Lordship.
Annexure J.
Your Lordship, at page number 57.
Annexure J, Milord.
Yes.
Assessment order.
The contentions after at para 6, Your Lordship, at the bottom end of the page, Your Lordship, the contentions raised by the assessee have been gone through. The bank account furnished by the assessee does not have the first page identifying the account holder. The copy of the agreement of sale of land entered into with landlords are not furnished. Further, apart from stating that funds were transferred from his bank account and wife's account, no supporting evidences have been furnished to his to his account. The explanation offered by the assessee has, as above, is incomplete, and the explanation is silent about the amounts in his bank account or wife's bank account. As such, the explanation offered by the assessee is not acceptable. Your Lordship, the assessing officer's contention in this matter was, Your Lordship, that there was a deposit of about 52 lakhs in his bank account, Your Lordship. Out of this 52 lakhs, Your Lordship, 11 lakhs pertain to loan taken from his wife, Your Lordship.
But that is on merits, sir. That is on merits.
Your Lordship, if that 11 lakhs would have been accepted, Your Lordship, then there would not have been any scope for the assessing officer to reopen, Your Lordship. Under 149 1B, the escapement of income should be more than 50 lakhs, Your Lordship.
No,
My-
now this, just one. You'll have to redo it. It's reassessment. For reassessment, you have to follow 148 AB from that stage if notice is not served. If it's a fact that notice is not served under 148 AB, then you will have to redo it because 148 AD is an order that you have to pass. It's not a regular assessment. No, merits we can't enter into. When you are going to reopen and enter into reassessment proceedings, 148 AB and AD will have to be strictly followed. Only if you cross those two hurdles and satisfaction, only then he must be subjected to all this, not other.
There's not even any email at all. What the email ID is, no email ID.
Okay, you file your objection. Now you can't drive him to the appellate remedy till you establish that the procedure under 148 AB is followed.
Your Lordship, I am a retired employee, Your Lordship,
Let
and
us-
don't have any tax income, Your Lordship.
Prior to this, you have not filed your return.
I have not filed, Your Lordship.
Let us see.
Only in the year.
Let us see.
Only-
Let us see. You filed it.
only
Take your stand. Take your
2012.
stand. The counsel for the petition.
Submission, page number 53 has given the
No, but that is at the subsequent stage. You cannot reopen as a matter of course. If you are going for reassessment, you must strictly comply with 148 AB and 148 AD. Let us. You want to redo it, I can do it. Otherwise, you take instruction, file objection. From the stage of 148 AB to the 148 AB, the petitioner submits that the petitioner is called in question the correctness of the 148 capital A within bracket small b notice at annexure A, comma, order passed under 148 capital A within bracket small d at annexure B, as well as notice under 148 at annexure C, and the order under 147 read with 144 at annexure J, as well as the notice of demand under section 156 at annexure K. Petitioner is also challenged the order under 147 read with 144 at annexure J, the demand notice at annexure K, and the reassessment order at annexure J, demand at annexure K. The primary contention of counsel for the petitioner is that petitioner was not notified and communicated with the notice under 148 capital A small b, and accordingly all subsequent proceedings leading to the order under 148 capital A small d required to be set aside. Is submitted though at a later stage the petitioner has responded to the notice under 142(1).
Yes, Your Lordship. 142, Your Lordship.
Under 142(1). Dated
21, 22.
23. However, it is submitted that the proceedings prior to the reassessment proceedings is a right conferred by virtue of 148 capital A small b, and order to be passed after considering the say of the petitioner under 148 capital A within bracket b, and unless such procedure is strictly followed, the question of looking into the validity of the proceedings subsequent to the notice under 142(1) does not arise. there is, in light of the contentions raised and the assertion that the notice as regards the notice under 148 capital A B was not served. There is a merit in the contention. The petitioner's rights as conferred under section 148 capital A B, culminating in the order under 148 capital A D, is a substantive right, though appears to be procedural, and it is only after in compliance of the procedural requirements under 148A within bracket B and order being passed after hearing the petitioner under 148 capital A small d, that question of reopening the assessment would arise. So accordingly, the order under 148A capital A D at annexure
Your Lordship,
34 minutes.
is
at annexure B is set aside. Good start.
page 32.
Consequently, annexure B is set aside. Consequently, the orders, consequently, the notice under 148 at annexure C for the assessment year 2015-16 is set aside, and the orders passed under 147 read with 144 at annexure J, as well as the notice of demand at annexure K are set aside. The matter is limited to the stage post notice under 148 capital A B, and the SSC is now required to file his objection to the notice under 148 capital A B and the authority to consider and proceed further in accordance with law. Accordingly, petition is disposed of. Yes.
Much obliged.
Now you just make a list once again of the orders that have to be set aside, and
Yes,
just pass it over to the court office.
Yes, Your
Yes, 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 yes. WP. Only. Yes, yes. It has a similar order, but let me have a look at it. We'll have it on Friday. We'll have it on Friday and dispose it of it. That is not released. We'll have it on Wednesday on top of the list and discuss. It's the matter on Wednesday on top of the preliminary hearing list. Yes. Scan it. Twenty. Sixty-four is the assessment order. Show cause. Yes. No, show cause notice was issued.
This is finding. Meanwhile, the associate made a request. The grievance addressor, email ID, action case. To allow him to find the reply.
This is pursuant to the show cause no opportunity under the show cause notice.
Just to the grievance address.
Where do you find that finding? The assessment order he refers to. Where do you get the finding of his rejection of your adjournment application? Yes. Not filed. Then verify. So you verify if it is fact. That you verify. Actually, it is a factual aspect. Either it is filed or not filed. Then you check it out. Check it. We'll have it next week. Relist the matter in the same stage on next witness. Let us see. On just wait, let us. Just- Yes.
Now, since the older people they should get the money back. So the vehicles that are being stationed at the same authorities and they should be back. As per I should be the vehicle station for 1 years. Offers the I'm sure these should be like
Direct him to give a fetch representation to the jurisdictional RTO. Petitioner has sought for issuance of the writ of mandamus to the respondent to consider the representations at annexure F dated 15 September 22 and to dispose of the same within a time frame. In terms of the representation at annexure F, the petitioner submits that the petitioner company is engaged in the business of finance, purchase of commercial vehicles and passenger vehicles. It is submitted that the RTO authorities had called upon the petitioner to deposit the road tax with respect to the vehicles which were hypothecated and in possession of the petitioner company. As regards such notice, the petitioner submits that as vehicles though in the possession of the company, the vehicles not being used, therefore the petitioner is not an operator in terms of the Motor Vehicles Act. Various other contentions have been raised and the petitioner has sought for a refund of the amount paid as tax. It is submitted that such representations have not been considered. Third AGA Sri N. Kumar, appearing for the respondent, submits that the representations ought to be addressed to the jurisdictional RTO, putting forth all requisite details, and the same would be considered in accordance with law. Accordingly, petition is disposed of. The petitioner has to file fresh representation before the jurisdictional RTO, setting forth the details as may be relevant to consider the plea as made out at present at annexure F. If such representation is made before the jurisdictional RTOs, regional transport officers, the same would be considered and order is passed within 4 weeks from date of receipt of the applications. Needless to state that the respondent authority has liberty to call upon the petitioner to file and produce such other documents as may be required for effective disposal of the representations. Accordingly, petitions disposed of. Yes. Yes, income tax. Yes. Take instruction. We'll have it. Have it next week. Third constitution relief accepts notice for the respondents. This is the matter in the preliminary hearing list on 15. No, just come again. Both the appeal will have the appeal before the tribunal. Yes. Yes. So now what is happening now? This is to be treated as 8A. But what is this now? Is this not a notice? The invoice value is 73 lakhs. Difference between, so there's a difference between
One more announcement saying that unless the paid tax is not removed from tax, that also is necessary.
the petitioner yes, petitioner has sought for setting aside of the demand slash recovery notice dated 1/6/2020 at Annexure D issued by the second respondent and endorsement at Annexure H issued by respondent number 3. Petitioners also sought for setting aside of the demand slash recovery notice at Annexure D issued by the second respondent and the endorsement at Annexure H issued by the third respondent. Petitioner has sought for appropriate direction to respondent number 2 and 3 to remove the vehicle of the petitioner from the blacklist as is contained in the report at Annexure F and to release all documents pertaining to the said vehicle. Next. Petitioner submits that the respondent authorities have got issued a notice at Annexure D whereby it is pointed out that there is a discrepancy between the ex-showroom price and the invoice value and the price available on the internet. So difference between the actual showroom price and in Badidira.
What is the notice of the whereby it's from the doc that there is a discrepancy between the ex-showroom
Price. And the invoice price and notice and a demand has been raised. He submitted that the procedure described under the statutory scheme requires to be adhered to an opportunity granted to the petitioner before such steps are taken. Reliance is placed on the order passed in WP 8107 of 2020 and submits that the matter may be disposed of passing similar directions. Learned AGA submits that the order passed in WP 8107 of 2020 lays down the correct procedure and matter may be disposed of on same terms. Accordingly, without entering into the other facts of the case as the matter is being disposed of, laying down the correct procedure to be followed, it is observed that the notice at Annexure D may be construed as a notice under Section 8A of the Karnataka Motor Vehicle Taxation Act 1957, and the petitioner may be permitted to file his objections to the said notice. The authority then to examine the petitioner's reply and pass appropriate orders in accordance with law. Learned counsel for the petitioner further points out that which is at Annexure blacklisting points out to Annexure F column the counsel for the petitioner refers to the report at annexure F and also submits that the blacklisting requires to be set aside in light of the direction whereby petitioners granted an opportunity to reply to the notice now construed as a notice under 8A. Accordingly, in light of the order passed above, setting aside the in light of the order passed above, whereby direction is issued to construe annexure D as a notice under 8A, the report at annexure F requires to be set aside and the endorsement at annexure H is consequently set aside. All contentions are kept open.
Accordingly, in light of the order passed above, whereby direction is issued to annexure B as a notice under section 8A, the report at annexure F request is set aside.
So far as blacklisting of the vehicle, which is the other matter. Similarly, 65. Same. F is blacklist. The endorsement. So same. Identical order can be passed. Same order. Huh? No, we have not mentioned. I have not mentioned any dates. Same order. Same annex. Exactly matter. Yes. ಏನಾಗಿಲ್ಲ ವಾಪಸ್ ಹೋಗ್ಬರ್ಬೇಕು.
नहीं लग रहा पार्थ सारथी वगैरह तो कोई नहीं है
अभी नहीं किया होगा
हम्म
Yes. Yes, Hem Kumar, you. Yeah. Such notice correspond one World Council. But 3, 4, and 5, who left it? World Council G1 is directed to accept notice for respondent 3, 4, and 5. Yes. You have an extra copy you can give. Yes. Yes, yes. Next year M3. Yes. 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 Now this is the classification of who come within the central zone. Taxpayers falling under jurisdiction of the center. Yes. Annexure. Yes.
Central authorities. School additional director, DG, GSI, and
Yes.
on the same issue, same day, they initiated action on 30th January 2018. First issue, the same day cannot DGA is also issued. Then I got to see it's got connection H2. Page 127.
Yes.
Commissioner Bangalore, not Commissioner, he also has issued a summons to me on the same issue. There are because of it's different notices. Many cancel on the same issue. That is why I got one of these things. You have respected the jurisdiction and you have taken the series on the state. That is the policy. Jurisdiction itself is the central authority. Because some television notice cannot arise because they are not.
Now F and H is by state authority.
And H2 by laws is by central.
Central. So now what?
31,122.
Now what is to be done?
Also taken last. Marriage. This is the first round. One more. State authority. The direct of enforcement. It may not that it's enforcement. The notification issued to the state itself cannot issue notices. They can only do inspection. They can only do certification exam. They can't issue notices. That is what
173. Section E. Section E also. The information of commercial tax enforcement. Page 170.
Yes.
Enforcement. See the sections under which he can exercise powers. Suppose 1971, 73 and 74 are absent, which is the scope of. Then it goes to 120. Second round. Therefore, the enforcement office is not everything they should be focused, assuming they had. Third, my lord, there exists an issue whether the technical kitchen cannot take the benefit of 9%. Stated with existing councils. Existing council by lords, specifically by lords. It's a connection, yes, page 21. But restaurant service is depending on restaurant service is something by way of or as part of any service goods being or any other article provided the restaurant eating joint yes canteen without consumption or as such or any other article. The expected note for this classification is the state and restaurant services provided by restaurant state and similar unique series, including internet services, student services, home delivery, then scale the internet services, home delivery services, consumption of all considered as restaurant service. That's by any. It can be on both delivery or without agents. Not just recommend the course. Standard and service provided there. Without agents and covered as why this 1970s was another Indian cadence. You won't need this. GST may not a very bad northern India cadence decision not very schedule go on GST and introduced it at 80. Section Q1.
Yes.
188 lots 6. 106 something. 6.
Page 180.
88.
There's some page missing. Yeah. You can read it. Yes. Physical codes. Page 188. Schedule. Yes.
Composite subject. Composite subject will not be definition in mixture of service and goods. But say they are all a composite subject can be treated as their services. If supplied by way of a part of any service, together and a part of goods, being food or any other article or anything other than alcoholic. As a supply of service can be different. And say they are all such things. It will not be classified as goods. It will be classified only as services. First one that we got classification, so they didn't tell me. After it, scheduling is
This is that interim order at page. Is that correct? Yeah.
good. And this data. Liquid. This is the this is the key. This is all the matters. What is having cost of speeds? Just also connect. And also deposit 20%. Cheap to bill 20%. Also reward to the extent of 20%.
Now, all this have to be clubbed. One part, but then on merits. On merits. It's the matter on 22nd. Respondents not to take any precipitative action till the next day. Not to proceed further to the next day. Yes. Let us. No, we'll take up one matter, and then we'll see how we are going to work that.
In other matters, parity
Let us file your objection. Just one. Government. Krishna. That dictating matter. Government advocate and dictated it. You know the matter, no? No. Krishna was there. So you can ask him to be present. You have to dictate the order. There's some small. Let it be done in his presence. I can continue. Yeah. So he has given an instruction yesterday and indicated on two aspects. No, otherwise let him be there because in case some small clarity. Shall I have it at 2:30 or before that? 2:30. Ask the government advocate also. Yes, which is that matter?
the date, here shows notice issued on the same set of issued on the same kind of bank salary submission against. People doesn't have my problem. Those people get it against me. And third show was not issued. And again, fraud, full statement, or submission of banks. Second show was notice cannot be under the same provision. And just ask on the judgment of loan.
So now, in the present case, refund has been granted after adjudication.
After education, under section.
Now, the contention of G1 is that in all matters, it will be only after adjudication. But if we were to construe so, then 73, isn't it?
73 and 74 are same years.
Will become this what he is submitting.
But
So that correct. But in so
again, this case, state authority. State has said, accepted my transactions and added that these are all exposed. I'm saying yes, the authority state that these are not exposed for
same aspect is now sought
sought
to be reopened by. Now, the other point, whether 73 insofar as refund could be erroneous refund,
that can be only a case of mechanical refund, not a refund actually. Officer necessarily has an order. There is something about the section. They have a power to devise. Another officer cannot take such a second judgment over that order which has been passed after application.
so according to 73, at the most will apply only for those prima facie on the face of it.
There is a mechanical order without application of order. That mechanical refund.
That's the only way to harmonize 107 and 70.
The other point also, there is a super notice already pending. Can a second super notice be issued? The process no. This is the judgment of the non-host. Just one small paragraph.
Nara? Yes.
The first SPM on the other hand, the second and third was on taking a suspension of that. On the part of the SC as the transfer already knowledge of the authorities. Generally, the lead taken, the outside judgment and respect to the stakeholder. But here, this so-called notice issued in 20. And the so-called notice issued in 20. Still has to be confirmation and issued for subsequent meeting and now
Has the same order as in the
what is what? Not the mechanical order and order. That doesn't distinguish between the mechanical order or past tense. One. So that I bit about the first round number 1 years. I number the content what was. And our second round is also okay.
intended by learned senior counsel, intended by learned senior counsel appearing to be petitioner. Now they issued a show cause notice.
That's it. One show cause notice is already pending for what it says.
So now fresh.
In addition to that, alone on the same cause of actions.
Cause notice issued.
Either of them has to stay or not.
At annexure A is a show cause notice that is issued on the same grounds as an earlier show cause notice, which is now pending adjudication. Accordingly, by relying on the judgment in Nizam Sugar Factory versus Collector of Central Excise 2006 197 ELT 465, he submitted that the impugned show cause notice is not legally tenable. Subject to further consideration, there would be a stay of the show cause notice at annexure A and subsequent proceedings. Statement of objections to be filed by the respondents, and the respondents are at liberty to know the matter in the event after filing statement of objections, in the event circumstances are so made out. The learned counsel Sri Jeevan accepts notice for respondents. Like that's already ordered, is it? Yes, yes. 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 On Wednesday. Relist the matter. Yes.
Have paid the money, tax, 100% money for the day. Lodged by you to the first proportion. We got to close that from the RP to the RP. Have paid the money, not often declared every day. I will gather the day. If you are considering that they are going to after that, they are walking to
Now you are the new company. Under the scheme of arrangement, what happened? You took it over under the resolution process. Just a minute. Oh, yes, tell me. Paragraph. Yes. Yes. Which paragraph? Read the paragraph. 120. Yes. Yes, sir. Next week. And Council Madan Mohan to the assets committee, the first respondent. Land Council Shri Shamati accepts notice for the second respondent. Consideration of interview is kept open. List the matter on Thursday. So let us see. Thursday. We will list the matter on 16th. On the next date, we will consider. Next date. Let us. No, just wait. Let us. Next week we'll pass that order. If anything happens in the interregnum, I'll set it aside. We'll have it on next Thursday and I'll pass the considered order. Nothing will happen in the interregnum. If anything happens, next date I will set it right. No, let us see. Let us just find out. Let us. Yes, sir. The Indian materialist orders. Indian materialist orders. Yes. 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 Sir, then you are referring to page 115. Yes. Where do you get that? IGST breakup. Yes. 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 So now it's come for consideration of interim period. Yes. Take me to the division bench. Page. Yes. Yes.
Supply of goods for stage. My customer who supply of except when the voucher itself identified the voucher would remain. There will be
Yes.
I will run through the facts. That's
So now here in this, what have you challenged? No counsel for the petitioner. Admits that the legal issue in the present case stands covered by the order passed in WP 5569 of 2022, wherein this court while setting aside the order passed by the appellate authority, affirming the order passed by the advance ruling authority, has declared that vouchers do not fall under the category of goods and services and hence are exempt from levy of tax. In light of the same and subject to further consideration, there would be an interim order of stay of annexure, orders at annexure A and B. The respondents are at liberty to seek for modification of the interim order upon filing of statement of objections if state circumstances are so made. The dictation of the family after 25, the 29. Leave it only. And the judgment is on the this is Dinesh Kumar judgment. You have a copy of that? The petitioner has challenged the nature B, which is in the nature of demand, and submits that the respondent authorities have raised the demand, noticing that there was a big discrepancy between the ex showroom price and the invoice price. Reliance is placed on the order passed in WP 8107 of 2020 and it is submitted that the demand notice at annexure B will be construed to be notice under section 8A of the Motor Vehicles Taxation. 8A of Karnataka Motor Vehicle Taxation Act 1957 and petitioner will be permitted to file his objection. Rules mean order passed in WP 8107 of 2020. It is in light of the directions passed in the said writ petition. Present writ petition may also be disposed of, directing that the demand notice essential be treated as a notice under section 8A and petitioner may be permitted to file his objections to the said notice. It will be considered by the authority and appropriate orders be passed. Any blacklisting? No. Accordingly, petition is disposed of in terms of the above direction.
That's
43 and 33, 43 and 33. Hmm. Thirty-three, 45 and 50. Now in these three matters, interim order is granted. On same at 2:30 we'll take it. And then we'll club it along with the other matters. The list for no, last you had given a list, is it? So 33 and 45 we'll take it up, then we'll club it and then post it with the, you can give that list. Two 30. Yeah, good. Give me a list.
ಫೋಟೋ ಇದಾಗಿಲ್ಲ ನಾನು ಓಪನ್ ಮಾಡ್ಬಿಟ್ಟೆ
ಇನ್ನು ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ಲ.
ವೇಟ್
मिलवा देता हूँ काम चालू हो जाएगा कर देते कुछ और सपोर्ट लगेगा फिर वो अटक जाएगा और दौड़ भी क्लियर हो जाता हाँ वो बोल रहे थे तो क्लिक जो कि एक विषय इनकम है आउटपुट हाँ शायद मेरे से लास्ट टाइम जब बात किया तभी पे उसका भी
Hari?
हाँ मानो
हाँ तो जो उसने वो मेल भेज दिया कैंसिलेशन का 19 जून तक का क्लेरिफिकेशन का दिया है
ओके
और वो मैंने आपको व्हाट्सएप किया है
हम्म
और इसके शीशम के पापा और वो एक शेड के अंकल वो एक मतलब सेल टैक्स प्रैक्टिशनर ही है वो भी उधर ही है बांद्रा में
हाँ
उनको मैंने बोला था तो वो गए हैं तो 5-10 मिनट में मिलेंगे तो अगर जैसे वो नहीं माना तो एक बार पापा को बोलो आपसे बात करने को वो बोल रहा था कल आपके सीए को बिजी है तो एक बार आप चाहिए तो फोन पे उससे बात कर लेना कैसे अगर कुछ नहीं वे आउट निकला तो
ठीक है
और अपन ने उसको अपलोड तो कर दिए बिल को तो उसमें तो कोई इश्यू नहीं आएगा ना
नहीं
नहीं वो मेरी बात हुई तो वो ऋषु क्या बोल रहा है कि वो लोग तो वो नलीफाई भी कर सकते हैं जैसे रिफंड को वो बोले जैसे वो लोग रिफंड को नलीफाई भी कर सकते हैं भले आपने वो किया है वो लोग के हाथ में पावर से रहता है
वो बात की बात है एक बार का तो अगले को क्रेडिट दिखेगी ना
हाँ,
वो दिक्कत नहीं है
अच्छा
वो कोई इतना प्रॉब्लम नहीं है
उसके लिए वो लोग रिफंड वगैरह नहीं रोक सकते
आवाज आ रहा है म्यूट करो उसको यार, वो हाईकोर्ट वाले को।
हेलो
एक मिनट मोनू
अपन सिस्टम में कर भी इधर ही सिस्टम में आप करो
Page number. Okay. Okay. Council for the petition. Council memo it says right at the same. Yes, please. Petitioners. The videography. The videography.
Not again, the status of the land prior to commencement was by them. That since the Supreme Court went on appeal and after receipt of a representation, they are changing the nature of my land for 2 years. Even there are over basically making my land. And my lord is right that my lord is not now at this stage. My right is right. Not is right. Not is trying to see what can be done. It is somehow. All that I'm saying is my lord has already indicated that they should prepare a report. All the details of the land prior to commencement of work. We cannot do that without my law. If you say, I came there, I saw argument, I started to work. What I given my for the stage of the and then okay, we are going to stay. What is like before? Going Maharajah, and then I will be allowed to buy.
Prepare a Mahazar, but they may intimate you, you can watch. No, I'm not going to. I'm not part. You are correct, but I'm not imposing or interfering with your work. I'm disposing it of making those two observations.
Not a new. Not to say that they're being intimated. Yes. Not just to watch. And I will oppose every dog. They may consider them to be not considered. That's all. And all my grades, everything is there. What I need to see you are. And before you come in the work, grades are made out of reports.
I'll make observation. The petitioner have sought for issuance of writ of mandamus. Direct the respondent number 2 to consider the representations dated 12/4/23, 29/4/23, and 15/5/23. Copies of which are enclosed in Annexure R, R1, and R2, and seek for further direction to the respondent to stop further developmental activities till consideration of the representation. The petitioners claim that they are the absolute owners of the property in survey numbers para 2 only, situated at Medi Agrahara village, Jalanka, Bangalore, North, and survey number 30/6 and 30/7, situated at Viala Kere village, Esargata, Hubli, Bangalore, North. Next, it is further submitted that pursuant to the preliminary notification passed on 20/12/2018 under section 17(1) and 17(3) of the Bangalore Development Authority Act for the purpose of forming Dr. K. Shivram Karan layout. The petitioners have filed detailed objections to the preliminary notification on 6/11/2009. It is stated that objections were filed on the ground that the lands were horticultural lands. It is further submitted that pursuant to the endorsement at Annexure C, to the effect that the property was not viable for acquisition and same would be dropped. Petitioners had sought for conversion of the scheduled property from agriculture to non-agricultural purpose. It is further submitted that the petitioners, after having obtained no objection certificate and approvals, have converted land into non-agricultural purpose. It is further submitted that approval of layout plans have been obtained for formation of a private layout. Yes. In the meanwhile, it is submitted that by virtue of the orders of the Apex Court, final notification has been issued. It is further narrated that petitioners had approached this court in WP 31363-31367 of 2019, seeking quashing of the preliminary notification and final notification, which came to be dismissed. As against which writ appeal 295 of 2022 had been filed. which also came to be rejected. It is made out from the facts that the petitioners have preferred SLP bearing diary number 9330 of 2023. What is SLP number? 36015 of 2022, which is tagged along with the SLP diary number 9330 of 2023. Like, as filed SLP diary number 36015 of 2022. Next. It is submitted that the special leave petition of the petitioners now stands adjourned to 19/7/2023. Next. The respondents learned the senior counsel appearing for the respondents has drawn attention to the order of the apex court in SLP civil diary number 9330 of 2023 and submits that they are entitled for a similar relief. Next. It was submitted that since the Supreme Court is currently on summer vacation, listing of the matter has practical difficulties and they seek for some protection in the interregnum. It is further submitted that the respondent BBMP is changing the nature of the property by its civil works, and even if relief is granted at a subsequent stage, the change in the nature of property ought to be taken note of and documented so that the petitioner, so that equities could be worked out appropriately, or case would be made out seeking appropriate relief. Next. Third counsel Shri K. Krishna appearing for the respondent BDA submits that in light of the various orders of the apex court, no order of restraint could be passed, as it is the mandate of the orders of the apex court to complete the layout process expeditiously, and all matters are being monitored by the apex court. It is further submitted that this court ought not to intervene in the matter in light of the committee formed by the apex court filing its reports periodically before the apex court and the apex court passing orders thereon. It is further submitted that the only remedy available for the petitioners is to approach the apex court and seek for appropriate relief. Their contention. Is further contended that the assertion regarding approval of layout plan is contrary to the records. Heard both sides. For the present, it must be noted that the entirety of the issues relating to the layout are before the apex court, and apex court in previous orders has issued directions to the committee, Justice A.V. Chandrasekhar committee, which is submitting reports to the apex court and passing and the apex court is passing orders thereon. The case of the petitioner is that the apex court has been passing certain orders in, at the instance of landowners, such as in SLP Civil Diary 9330/2023, and they are also entitled to make appropriate requests for extending benefits. That is on the principle of parity. That is a matter, however, to be addressed before the apex court by the petitioners. The various orders passed by this court, including the division bench, make it clear that the court has limited role for interference in these matters, and the only remedy available for the petitioners is to move the apex court. Next. Though the senior counsel for the petitioner has sought for interim relief, it's a matter of propriety that this court not pass any orders that may have the effect of going contrary to the directions, contrary to the directions of the apex court in letter and spirit. However, it would be reasonable to ensure that there will be documentation of the change in the nature of property of the petitioner by the respondent BDA. Accordingly, while not acceding to the other reliefs sought for, petition is disposed of. The observation that the remedy of the petitioner lies before the apex, that in the event the Bangalore Development Authority does civil works in the properties of the petitioner, the Bangalore Development Authority is to prepare the report containing the status as prior to them embarking upon civil works. This order will come into effect from this date. Okay, for whatever is now, though Learned Council, the responding PA has submitted that civil work has already commenced. However, it is made clear that henceforth, for all works of the BDA, the status report of the nature of property would be documented. Petitioner's property would be documented. Needless to state that in the event petitioners were to obtain relief before any of the courts, the action of the respondents would be subject to the outcome of such of the proceedings that are pending. Senior counsel appearing for the petitioner submits that there has to be a joint survey. Such request is not acceded to, though the petitioners are at liberty to be present at the spot when BDA seeks to make the status. All contentions are kept open.
And the BDA may consider documents
BDA may keep a record of correspondence, representation, and other documents that may be submitted by the petition. Whatever they place on record will be clear. One, I have not passed any direction of joint survey, etc. But they may give some document saying we have done this ABC. Well, let it be. That is the only relief I can give them. That is the only relief I can give them. No, I have not enlarged. I'm smilingly, I'm sending them back. So the only relief is The lead- Oh, no, that I no that I've ordered that immediate no, no, immediately. No, no, it is report immediately you bring it that into effect. That I've ordered. I've ordered that is from immediate effect. So that it is.
Because if they don't let me know when the file will be prepared. No.
Let us see. It is needless to state that a videograph of the status of the land to be maintained while preparing the status. Yes. Yes, who appear Assistant Commissioner Central Tax. That counts even is right to take some notice to the respondent. You serve him copies, we'll have it next. Consideration of 60. Huh? Which is that interim order? Just one by one. Counsel for the petitioner. In WP 15959 of 2021, which reads as surrender. Accordingly, the present case also, there will be a subject to further consideration. There will be a stay of annexure C. Respondents to file the statement of objections. Liberty to seek for modification of the interim order if circumstances are so made out. Yes, which is the other matter? Yes. List along with the 8360 of 23. Yes, which is that other matter? List. Yes. 33. Same order. Same order. Same order. Everything. Annexure number. A of annexure B. Annexure B. Now, concept given. Right to accept. Yes, next. Just inform Jeevan. Let him not get a heart attack, you know, let's party in tomorrow. A of connection. Actually. This serial number 33, 45, 63, along with now, shall we have all these matters next week? Ah. 60. Next Wednesday we'll have 40. Just 1 minute. Forty-five.
Based on income tax information received in the DGIL, which is there in page 94.
Page
94 of the information. Income received there in the paragraph.
Yes. Yes.
The inputs received from the central board of direct taxes are the figure and notice as account and sales gross receipts for service which goes. And statutory income tax return forms are an idea. Whereas it appears the service provider has carried out activities for cover under the annual benefits. Then you note to back at page number 95, paragraph 4. After income receipt from CBD, it appears that the service provider has received consideration for the same fee accounted under section 194C, which is related to reduction of tax and social payment standard. So it is solely related
range of fees.
yeah.
Otherwise, you can.
Just
Petition here, the petition was filed in the petition here is company construction. Now, the entire income tax returns pertains to a joint venture, of which the petitioner is also a party to a joint venture, which has received a consideration from the KNFL, Karnataka Nilgiri or carrying out irrigation works. They have quoted the wrong plan number of the joint venture, issued a show cause notice to the petitioner instead of issuing a show cause notice to the joint venture, because the joint venture has received that income. It has issued the show cause notice, the letters, all the rest. Now the petitioner has not just the feelings of people that but also the fact that the issued to the wrong person. It is not the involved in this transaction. It is the joint venture who has received the
Anyhow, we have granted interim order, but you file your objections, and then we will delink it if let us. No, after just 1 minute. You've got your interim order, no? No, don't get into that. It will be strategic also. You file your objections, and then if case is made out, we'll delink it and have it separate. Yes. Next Wednesday. I'm directing it to be listed along with others. Yes. I've ordered it to be listed along. List along with. Yes. So what happened? Bank accounts are frozen since. What are the instructions? What is the stage of the adjudication process? This is the matter. The preliminary hearing list on Wednesday. You have to get instruction. Now you can't get it. Preliminary hearing list on Wednesday. On next date, if they don't respond, I'll consider passing some order. It's made clear that if instructions are not complete, court may be constrained to pass necessary orders. Yes, next. Just refresh.
Okay. There was a primary transactions of the other company. They have one right. We have merged. We have it on there. There are no transactions after that. All the transactions are.
But when in terms of the merger, now the petitioner company is declared.
The company has declared all the transactions in its financials and our tax as a whole. Assessment is also done. The entire
So now what has happened now? Where is the 148 AB notice?
notice the first notice issued on the first by company.
Yes. Yes.
Page 45.
Yes.
What the information that they have, all of which they speak to reopen the system. As per the information available in the office, it is compared to the model transaction during FY 2018 and purchase of foreign currency. So, the information happened by the risk management strategy. However, on the result of the data available on the file portal, it is found that the SSC did not file the account or assessment yet in 2019. This is the basis, the information of the basis of the proceedings are initiated. Now, I will see my reply to that at page 48. Page 48, connection D, not connection D. I reply to that. Page 49. That notice not
Page?
49. Another heading.
Yes.
As already stated earlier, various software India Private Limited had merged with the risk. With the effect of 1/4/2011, first sector report of the expected in 1.5 for event of the forward related to merger. So also, but yeah, I reply to this. Then I receive the notice. Fresh notice is issued. Page 50. By page 67, annexure H. Annexure H, page 67. In the name of the petitioner. This is not permissible for all. And ultimately, the 148 D order, 148 notice is issued in the name of the petitioner. Now, that's not permissible because our standard see 148. The one, no notice under 148 can be issued unless there is information with regard to that SSC. That means it comes as a state assessment. Now, the information that they had is that the income of the speech entity as a state assessment because they did not find the return. That is the information basis to suppose.
Referring to the petition. Submits that the notice the 148 A, the clause A for an inquiry as against the petitioner. And the subsequent notice under 148 AB is on the basis of information relating to Messrs. JDA Software Private India Private Limited, which entity has merged with the petitioner. Submitted that the information on the basis of which proceedings under 148 A are sought to be initiated must be information as regards the petitioner company to which notice is addressed and cannot be on the basis of information regarding Messrs. JDA Software India Private Limited. Matter requires consideration. Pending further consideration, there would be a stay of an executive and proceedings pursuant to respondent are at liberty to file their statement of objections and seek for modification of the interim order granted upon filing such objections. Yes.
Lordship. Lordship, this is for the assessment year 2016-17. Lordship, this notice and the proceedings is barred by limitation also lacks jurisdiction for various reasons. Number one, Lordship, under the new law, the maximum number of years based on which a reopening can be done is 3 years. If it is above 3 years, Lordship, besides the information, they must have evidence in the form of books, document or evidence in the possession of the assessing officer. So from 3 to 10 years, if you want to graduate, Lordship, the evidence must be there, not just information. In this case, Lordship, the assessing officer issues a notice under 148 AB outlining certain information. Lordship, the information which he outlines may be seen in page 37.
Annexure?
Annexure C.
Just 1 minute. 36. 36.
36, I'm referring to page 37.
Yes.
Lordship, he outlines here 4 transactions which he says he has obtained information from Enforcement Directorate. And he says these are credits in my bank account. And in my reply, I pointed out to him that the item 2 and 4 actually is a debit and not credit. So the information which he has received itself is erroneous.
The order is passed under 148 AD.
AD, overlooking this aspect which I have brought to his knowledge in my objections.
Now, if you remove those two transactions,
The other two transactions, Lordship, even according to him, is a share application money, which is a capital receipt and not an income.
what have they found in the 148 capital AD?
He simply says you have not filed the return, which is also incorrect. I have filed the return and I have also enclosed the copy of the return which I have filed. So first of all, Lordship, after obtaining information, he has to conduct an inquiry. Inquiry can be based on my return, which is already available. He does not do that. Secondly, the objections which I have filed, which when I say that these two are debits and the other two are share application money, there is a Supreme Court decision, Lordship, where it says share application money, any issue pertaining to that should be dealt in the hands of the shareholder and not in the hands of the recipient company.
Now, where is the order?
The order, Lordship, can be seen in page number 30, Annexure B.
Where is the AD order?
AD order, page number 30, Annexure B. Lordship may see page 31, para 2.
So where is the reasoning?
Reasoning, Lordship, can be seen in page number 34, para 4. In para 6, Lordship, in 33, he starts reasoning, and in para 44, he erroneously says, I have accepted these transactions when I have specifically pointed out these are incorrect information. And he himself says, I have received the money from two companies. And later on, when I produce the ledger balance confirmation, he says, no, these are, unexplained credits. When he himself says it has been received by two others.
Now you file your objections.
I have, Lordship.
There must be application of mind while passing 148 AD order. You can't, now the scheme is such that capital A, B notice. Then you have to consider and then pass an order. And when you pass an order, you have to record. Here, now what have you said regarding the two entries that he has pointed out?
Lordship, he
just wait.
Even deal with it.
Just wait. There's no reference in that AD order.
Yeah.
Not merits. Page? Paragraph? So that's his reply. Now you jump back, go down. Nothing. The counsel for the petitioner submits that so far as the 148 capital A small b notice, the petitioner made out a detailed reply at annexure.
As the annexure, Lordship, D in page 39.
In which specifically it was pointed out that the transaction dated 17/3/2016 and 28/3/2016.
Training like you balls.
Were in fact debit transactions. Debit.
Yes. One cancels the other.
It is further submitted that so far as the share application, what is that? Share
application money.
share application money, same is a capital
Capital receipt
receipt and cannot be taken
as income.
as income. Peruse the impugned order passed under 48 capital A D. Prima facie, there appears to be force in the contention of the petitioner. Accordingly, there would be a stay of
A and B.
Stay of
A, B.
A and B. Annexure A 148 notice, Annexure B is D order.
the order under 148 capital A D.
And notice under 148.
And the notice under section 148 at annexure
Annexure
A.
A.
at annexure A. So respondent to find the statement of objection, they are at liberty to seek for modification of the interim order if circumstances are so made out upon filing statement of objections. Yes.
Much obliged.
Fifty-seven. No, correct. Let us see. Next week. Relist the matter in the same stage on 14, 37, 39, and 71. Orders. Yes. There is the notice under 148A small b. What is the sum total of? One crore 17 lakhs 34,000. Page. Annexure B. Annexure B. Just 1 minute. Just. 65. Yes. Will state the counsel for the petitioner submits that in response to the notice under 148A small b, petitioner made out his reply in which calculation of capital gains has been made, as a result of which the income subject to tax would only amount to 28,64,839. However, it is submitted that the authority has not taken note of the same and has taken note of the income escape from assessment rather than income chargeable to tax while passing the order under 148 capital A D. Subject in light of the contention base, subject to further consideration, there would be a stay of annexure A1 to A3. Respondents are at liberty to same one. Yes. Yes, same Kumar, you appear. Instructions are complete. Next week. We discuss the matter on next Wednesday. Thursday, same stage. Yes. Yes, who appeared? It's covered. Covered. So just tell me what the facts. What is the issue involved? What are the facts?
like this. Yeah. How to take this case as we get into that. Because in these slides, page 126. I have
Yes. Take me to the relevant paragraph.
So, paragraph number 18.
Yes. So we'll simply say it's covered and then reproduce the directions and say these are. That's all. The operative portion of the order. I don't know how I missed this batch of discourse. Yes. The petitioners. In all these repetitions. All these repetitions. I thought for identical beliefs. Here A to B. Pointed out by learned senior counsel appearing for the petitioners that the matter is now to be disposed of in terms of the order passed in WP 971 of 2019 and connected matters disposed of on 11th April 2023. The operative portion of the order, the first petition, at para 20 reads as hereunder. Accordingly, all the petitions are disposed of in terms of the conclusion WP 971 of 2019. Operative portion of the order which is extracted up. Yeah.
Have to receive how much of amount from the client. So whatever it you do, it must be there.
File an affidavit. We'll have it on Wednesday. We'll take the affidavit. Deal is the matter on next Wednesday. Good copy. And council.
What is the time?
Yes. On? Thirteen. No, but no, just, but isn't this not independent? Two 50. Yes. What has been challenged before the appellate authority is the
main order was not for rectification. That main order
after the miscellaneous petition was filed, another order came to be passed. Altering, correct, that by virtue of that miscellaneous petition which was partially allowed, a fresh order was passed. No, no, before indeed. What I'm saying is in the appeal, in original ITA order, correct. Now, by virtue of the miscellaneous petition, some change was effected to the order of the tribunal. Now the tribunal has amended the original order. Now that amended order, is it before the the miscellaneous petition was disposed of on
Miscellaneous petition was disposed of on 5/9/20.
I-9?
Holding that particular order is funded. The order that one has that three times in the original order, the following paragraph is added. Original order is funded. That original order, they have made a appeal to that.
But now the appeal has been admitted. The appeal has been correct against the original order has been admitted. Now it was admitted on 22/7, 22. It was admitted 21/6/22. Meanwhile, the miscellaneous petition came to be allowed subsequently on 5/9/20. The effect of the miscellaneous petition being partly allowed, though you are aggrieved by it, will result in correct, but the effect of the allowing of the miscellaneous petition for whatever it's worth results in altering the that is there. That is there, but no, the effect of rectification for whatever it's worth, results in altering the original order.
Yes, it does.
Now that original order is subject matter in the writ appeal, in the appeal. So though it's a subsequent development. Now can this not be a subject matter of
Identical issues which have arisen, because when a matter is pending in SLP before the Supreme Court, and the review petition is filed before the High Court, and the Supreme Court has dealt with all these issues in 2000 volume 5 S, and has said that till the appeal is admitted by the higher court and the order of the lower court is varied, there is no merger. And while the matter is pending in the higher court, a review petition can be entertained by the lower court, and the review petition can be discussed upon merits. Direct judgment of the Supreme Court, 2000 volume 5 S. I forget the name now, I get it immediately. So that is no problem at all. I'll satisfy
the point is the coordinate bench. Now has taken that very same.
I don't see any difficulty in this at all. I can satisfy my lord on this.
In the case, yesterday they pointed out, in the case of Deputy Commissioner of Income Tax versus H.V. Shantaram,
I deal with that also.
the court has observed in the identical factual matrix, stating on the division bench appeal is provided for. This court should not entertain it.
I'm very conscious of that. What my learned has not pointed out is, in recent years, there are two direct judgments of the Supreme Court dealing with writ petitions filed by the revenue against orders passed under 254(2). And the writ petitions were entertained and disposed of on merits, both by the High Court and by the Supreme Court. And the Supreme Court has not proceeded on the footing that those writ petitions cannot be entertained, or that the only remedy which is available is that capital. So I'll answer every point made by my learned. I'll complete answers to it. And the fact that the appeal against the original order was admitted, because it is a matter of no consequence as it's still an order of that. My lord is with me. Because my learned is very important to understand. On merits, my learned is not prepared to make any argument at all. Very, very important to understand that. Yeah, that is right. No. You're not asking for the reason. I'm only saying, but as a matter of fact, I'm stating, my learned has no submission to offer on the matter of merits. On my basic and fundamental contention that the matter is fully and squarely and completely covered in my favor by Mahindra and Mahindra. 28(4) is not applicable.
No, that is there, no doubt.
No, therefore, that has profound consequences. I tell my lord right.
That position of law, despite whatever the revenue says, appears to be well checked. That there is no issue.
There is nothing else in the matter.
But then now the only question is that suppose we were to pass some observation or finding made, that would have an effect on the appeal. That
the earlier appeal modes can be. I will withdraw the earlier appeal because any orders. There is no problem in my way at all. My lord is with me on this. That the matter is fully covered in my favor by Mahindra and Mahindra. Then the only other issue is I have to deal with the two judgments which my learned has judgments of the learned single judge of this honorable
the position
that it should go under and not come by way of a regulation. So I have several answers to that. Let me place those answers before my lord. I have to deal with those two judgments which my learned has cited. I am fairly admitting that, and I will give a complete answer to that.
But now the appeal is still pending.
No, that doesn't make any difference at all. Even when an SLP is pending, it has been held by the Supreme Court in 2000 volume 5 that the review petition against the very same judgment can be entertained and disposed of on merits. And the review can change the original order beyond recognition, thereby making the pending SLP virtually infructuous. There is no merger till the appeal is admitted and then decided by the Supreme Court on merits. Same issue arises here.
Now the other doubts that I have.
Yes, certainly.
Now these two you'll have
These two
to.
judgments I will deal with. I will deal with them immediately.
Then apart from that,
Yes.
now under now this
But my lord has not seen the judgments of the Supreme Court, which deal with
writ petitions filed by the revenue against 254 orders, which were disposed of on merits, and the Supreme Court is perfectly content with deciding the matter on merits. It does not say that the writ petitions are not available.
Assistant Commissioner of State Tax versus Commercial Steel.
Commercial steel, yes.
Justice Chandrachud judge
Very well.
on this point. So that
Two other judgments. One is Saurashtra Stock Exchange and Reliance Telecom. I learned to rely mainly on Reliance Telecom.
that apart, now these two judgments will have to, how are we to cross that?
Yes, absolutely.
Now this order, the miscellaneous petition,
Yes.
after the miscellaneous petition was allowed, would amount to an order under 254(2) against the order of 242
Yes.
by the tribunal. What is the substantive remedy?
Substantive remedy, according to me, is a writ petition. When the issue on merits is covered in my favor by the judgment of the Supreme Court, then there is no substantial question of law which arises, which can be canvassed under capital A. Let me satisfy my lords on that. Can I go step by step?
No, that will come to it. Now, insofar as it's your contention that it would be an exception to entertain a writ petition in case of jurisdictional error, etc., where there's a judgment of the Supreme Court and which is binding on the authority, or there's a Karnataka High Court on that point is referred to.
No, the two judgments in the Karnataka High Court, no such issue arose.
So there's one.
Where there was a binding judgment.
41, one judgment referred to in the assessment order,
Yes.
which goes in favor of the interpretation you're placing under 41.
Yes.
So
That is the Bombay High Court judgment in solid containers.
let us.
Yes,
So-
that's an earlier judgment.
No,
That is long before Mahindra and Mahindra.
according to you, an order of the Supreme Court is not taken note of, that by itself will be a
Basic jurisdictional error.
error, being an exception to exercise of
Correct.
jurisdiction,
Correct.
and can be entertained.
Correct. And also, when the issue of interpretation of 41(1) is already covered by a judgment of the Supreme Court, and there is no substantial question of law which remains, which can be agitated even under 260. I have gone under 268. But then, well settled law on the point is, what is the substantial question of law? It's a question of law on which there is no binding judgment of the Supreme Court or High Court. If there is a binding judgment of the Supreme Court or High Court, then there is no substantial question of law. If there is no substantial question of law, then 260 capital A is not necessarily a remedy which is binding on me. And this issue did not arise in the two Karnataka High Court judgments, which my learned friend strongly relies on. There I will point out the nature of the questions which were raised. There was no question of a binding judgment being disregarded by the assessing or appellate authorities. Therefore, and the issue which arose there was questions of law which could possibly be canvassed as substantive questions of law. But the writ petition was also dismissed on other grounds as well, because it depended heavily on factual issues. Whereas there are no factual issues at all in my case. And on alternative remedy, there is a recent judgment of the Supreme Court, Godrej Sara Lee, which I will place before my lord, which completely alters the legal landscape. No.
That's why I'm sharing. Let us
That
just to get just to overcome the observations made in the group.
Object doesn't arise here at all. I will point out
Let us
no, sir. The long and short of it is not right. I want my lord also to take a broad perspective of this. Even though on merits the matter is squarely covered in my favor, my learned friend is raising technical questions, the effect of which, if accepted, would only be that the matter would remain pending for various courts, tribunals, and authorities for a virtually indefinite period of time. It's something It should not be taken into account in the exercise of discretion, not while executing a repetition. Because he has no answer on merits. Let us be very clear about it. There is no answer on merits. I'm sorry, Vinos. I'm sorry. There is the judgment which speaks for itself. I did not interrupt my learner in this manner at all. I'm not. Because we started the argument, we have gone ahead, we have finished this argument. I'm now responding. I'm in the stage of rejoinder.
But just to clarify, he has not gone on merits.
No, that I understand. I'm only pointing out on a plain reading of the Supreme Court judgment. Unless there is a debit, unless there is a claim for deduction in an earlier year, 41(1) does not apply. It's as simple as that. It is nobody's contention that I have claimed a deduction. And number two, it is impossible for me to claim a deduction. Let us understand that also. If I borrowed money from a bank, it is just a liability in my balance sheet. If that liability is waived by the lender, then that amount gets credited, gets wiped out from the liability. Now that wiped out amount of the liability, whether it is income or whether it is a capital receipt, has to be seen. Supreme Court lays down one very clear principle. To see first whether that amount has been allowed as a deduction in the assessment assessment in any past year. That is the only test. If it has not been allowed as a deduction in any past year, there is no way in which you can make it come under 41(1). So they relied upon 28(4). On 28(4), Mahindra and Mahindra has given a complete answer, saying that if it is a monetary amount, 28(4) does not apply at all. So waiver of a loan.
But why can't, I'm just thinking aloud.
Yes.
Why can't you withdraw the appeal with liberty to revive?
Sorry.
Why can't you withdraw the appeal with liberty to revive after conclusion of this?
So I also want to point out that appeal is virtually infectious. 4 paragraphs of the original order have now been substituted. How can I maintain the original appeal? That order has ceased to exist. That order has been changed beyond recognition. 4 paragraphs have been deleted and 4 paragraphs have been put in. So I have grave doubts about whether the original appeal can be maintained in that form at all or not.
But why can't you withdraw it? It's liberty to revive.
Yes.
After you explore the
I
possibility.
only say one thing, Lord. My Lord, I would only beseech my Lord. Kindly postpone this aspect of the consideration. Whether I have some alternative or whether I can do something else. Then my Lord has heard me on alternative remedy. Alternative remedy certainly will not, my learned has made a point. Cited 2 judgments. I have to deal with those 2 judgments. If I cannot cross that bridge, then my Lord may put that question to me again. Then it will be considered. But if I may satisfy my Lord that there is no question of alternative remedy in this case at all, then my Lord may take a different view of the matter. And on the question of whether there is virtue or not, I'll satisfy my Lord, there is no point at all. But I only want my Lord to understand one. The Supreme Court judgment is crystal clear. It does not admit of any 2 views at all. If you don't have a debit in an earlier year, you cannot have an addiction in this case. It's as simple as that. And it has not been contended by anybody in the assessment order, in the appellate order, or even in the pleadings, or in the arguments, oral or otherwise, that any deduction has been allowed in respect of this amount in my assessment in any earlier year. And if the department wants to invoke 41(1), the smallest duty that would be imposed on them is to at least articulate the contention that a deduction has been allowed in an earlier year. They have not done that. Be that as it may. Let me issue merits and focus only on the issue of alternative remedy. My learned friend contends, that with some justification, that I have an alternative remedy under section 60(. In support of which he has cited 2 judgments of the learned single judge of this honorable court. I'll come to the judgments in a moment, but first let us understand. 260(a), the alternative remedy, grants the right of appeal only if there is a substantial question of law which arises out of the order of the tribunal. That question of law has to be formulated, and the division bench has jurisdiction to decide the matter only on the question of law which is so formulated. Now, what is the substantial question of law? This was decided by a constitutional bench of the Supreme Court as far back as in 1964, and it has been consistently followed thereafter. But in the case of Sunilal Mehta versus Century Spinning and Manufacturing, giving judgment. I mean, my lord will go to page 6. The page number is at the bottom. Actually, page 4, sorry. Page 4, page number is at the bottom. Please see the middle of the page. The lordships consider what is a substantial question of law. Because their questions were raised on the interpretation of an agreement between the parties. And there was a very serious and elaborate argument on whether that constituted a
You're reading at page?
Page 6. Page number is at the bottom. Page 4, I'm sorry, page 4. Page 4. Please go to the middle of the page. What is a substantial, my lord, has a sentence?
Then their lordships.
Yes, about 3 lines below that. After referring to
Yes.
Raghunath Prasad Singh,
Yes.
etc., I'm reading only what is necessary.
Yes.
What is a substantial question of law is between the parties, which certainly depend upon the facts and circumstances of every case. Next sentence is crucial. Thus, for instance, if a question of law has been settled by the highest court of the country, the question of law, however important or difficult it may have been in the past, and however much it may affect any of the parties, would cease to be a substantial question of law. My humble submission, which I am making, with all the emphasis at my command is, if my lord is with me on this issue, that applicability of 28(4) and interpretation of 41(1) are not substantial questions of law, even though I may find an opinion under this capital A. Because they are completely and totally covered by the Supreme Court judgment in Mahindra and Mahindra. Mahindra and Mahindra gives 2 clear propositions. 28(4) does not apply to a loan of money which is billed. Number 2, 41(1) applies only if a reduction has been made in the assessing assessment in the past year. And there is no such contention put forward by anyone. So therefore, this question, which I raised before the tribunal in the miscellaneous application, is not a substantial question of law, because it is covered in my favor by the direct judgment of the Supreme Court in Mahindra and Mahindra. If that is so, then my humble submission is 260 capital A cannot really be considered as an alternative remedy, much less an alternative remedy which I would be compelled to follow. That is virtually the wording of the Karnataka High Court judgment. Because it goes to a division bench. And why does it go to a division bench? Because it is a substantial question of law which requires to be decided. Therefore, it goes to a division bench. Now, please see.
कोर्ट में केस चल रहा है मेरा कोर्ट में केस चल रहा है
Let's not relax. My lord has copies. One is Sohan Raj, which is the first judgment of 2000. Sorry, first judgment is the judgment of Honorable Justice in 2000. In the case of Sohan Raj and others. In that matter, my lord will kindly see at page 149. Yeah.
Yes.
Yeah. My lord will kindly see. Para. Okay. Para numbers are there. That's fine. So I have the idea. That's why I have the page number. All right, I'll give you. In Sohan Raj, it is 260 ITR page 147. 260 ITR page 147. And I think the ITR copy has been given, my lord.
I have yes.
Yeah. Now, please turn to page 149. Please see, in this writ petition, which was rejected by this honorable court, Mr. Madhusudan Nayak, learned counsel for the petitioner in support of the reliefs sought in these petitions, firstly points out nearly 7 so-called mistakes committed by the tribunal, the common order dated so and so. There is no question of any matter being covered by any binding judgment either of the High Court or of the Supreme Court. Page 149. Now please turn to page 152. I am only pointing out that here the questions what could possibly be considered to be substantial questions could be raised and argued in 268. And that is why the writ petition was dismissed. In the instant case, page 152 right at the top, in the instant case, the petitioner's learned counsel points out several mistakes, which according to him are mistakes apparent from the face of the record. The mistakes quoted are that for the assessment years 1993, etc., assessments made were not with reference to any notice, and various points and contentions are raised. All of which are intricate points and contentions, factual points and contentions, which really cannot be canvassed in a writ. And it certainly can possibly be considered to be substantial questions of law because they are not covered by any binding judgment of any High Court or the Supreme Court. So it was in these circumstances that the writ petition was dismissed and the assessee was shown the door and asked to file an appeal under 260 capital A. The factual position in my case is entirely different. I have a direct binding judgment of the Supreme Court against which no contrary view is at all possible. And I am only saying, therefore, that there is no substantial question, there are no factual issues, it is a pristine question of law, and therefore I should not be driven to file an appeal under 260 capital A. And also because there is no substantial question. Now, please, the second judgment is another Shantaram.
More troublesome for you.
Yeah, no problem at all, no problem at all. Point out.
Rather me.
No, not at all. I don't think it's an obstacle in the way of the court at all. Well, what is with me on Mahindra and Mahindra covering the matter? There is no substantial question of law. If there is no substantial question of law, then 260 capital A cannot be a compulsory alternative remedy which can be forced down by the legislature. And my lord will still exercise discretion to decide whether to entertain the writ or not. That is my humble submission. I will point out how the Supreme Court has not considered clause 254(2) be a matter which can be exclusively articulated only by filing an appeal under 260 capital. Two direct Supreme Court judgments. Let me place that in moment. Because these two single judgments of this honorable court, they are of 2000 and 2002. Whereas we have latest judgments of the Supreme Court, just 4 years old and 3 months old. I'll place both before my. Now please see Shantaram. In Shantaram notes, please see page 158. Please see the nature of the issue. Then, my lord will see 158, the nature of the issues. It said it says the said order came to be passed in total disregard of the materials on record, made several incidental submissions, elaborating the submission. Finally, he submitted that since in the order include several unwarranted and uncalled for remarks against the petitioner and responsible officers of the department. So, on heavily factual issues was up to be canvassed in this writ petition also. And therefore, that is one of the reasons why the writ petition was dismissed. Now, my lord rightly points out to me that please see page 160. This is the troublesome part. See the last 4 lines at the bottom of page 160. I am very acutely conscious of this. I want to make a specific reference to it. But the question is, when a right of appeal is provided before the division bench of this court on a substantial question of law, where the scope of interference is wider in appeal and won by this court, whether it is appropriate to present the exam, whether it is appropriate for this court to proceed to examine the correctness of such orders. Therefore, the entire basis of this argument, this observation is there is a substantial question of law. that substantial question of law requires to be determined and can and should be appropriately determined by a division bench as contemplated by capital A. But if there is no substantial question of law, because it is covered by a direct judgment of the Supreme Court, then this logic, this reasoning for saying that that is the only appropriate method or remedy available to an SSC, and then he should not file a writ petition, and the court should not entertain the writ, because that reasoning fails completely. That reasoning is inapplicable. Because there is no substantial question of law to be decided, even by the division bench. Because the Supreme Court is articulated in the most clear terms. No debate in earlier year, no addition in this year. 28 court does not apply. So simple. Matter is in such a narrow context. No other issues which require to be determined. These two cases, the matters were hopelessly factual. 7 detailed errors were pointed out by Mr. Madhusudan Nair. Usual resourcefulness. Heavily dependent on the record. Here, all kinds of contentions are put forward. So there were substantial questions. Because substantial question includes a question which is substantial between the parties. It need not be a matter of great public importance, as has been laid down in a series of judgments. But it should not be an issue which is covered by a binding judgment, either of the High Court or the Supreme Court. So here there were substantial questions and there were heavily factual issues, which is why the writ petitions in these two cases were rejected, and I humbly and respectfully submit, rightly rejected by the learned single judge 21 years ago. Now, we see the latest position in matters before the Supreme Court. Now, we see the Saurashtra Stock Exchange. Let me give a little bit of background, and then I'll read. There's only one small paragraph today. Saurashtra Stock Exchange. Here, income tax.
Incidentally, one other question, just keep in mind.
Certainly.
Whether an order under 254(2)
Yes.
would be an order in appeal.
Sorry, I not these two judgments say that they are an order. I am frankly confess that. These two judgments say that. But according to me, it is not an order in appeal. It's an order rectifying an order which has been passed in appeal. And there is a clear distinction between the two. But since I am before another learned single judge of the same High Court, I don't wish to argue that question. I am putting it on other grounds. But I have grave doubts about whether it is an order passed in appeal. An order passed in appeal, if one reads the scheme of the Act, is an order passed by the appellate tribunal disposing of an appeal. That is an order passed in appeal. That's the language. But I don't wish to re-argue that point because there is a specific finding. It's my duty to point it out. In these two judgments of the learned single judge, there is an observation. Though it does not appear to be argued by counsel to the contrary. There is an observation that an order passed in the 154(2) is an order in appeal. It says that. So perhaps it's my duty to point out, but it runs completely counter to the scheme of the Act. Scheme of the Act is the tribunal sits and hears the appeal. The tribunal then decides the appeal by an order. That order is treated as an order passed in appeal. That order is final unless it is interpreted by a High Court or it is subsequently rectified by the tribunal. So the subsequent rectification is an independent order. It's a statutory order passed. And in this case, this order takes large chunks of the earlier order and virtually jettisons them and substitutes new chunks. So what is the effect of the substitution is a separate point. But therefore, whether the original appeal survives after this rectification is itself a very moot point. But even that cannot be decided for the purpose of entertaining the writ petition. For entertaining the writ petition, my humble submission is it is enough for my Lord to come to the conclusion that there is no substantial question of law because the matter is squarely covered by the judgment of the Supreme Court. That is so. The 260 capital A cannot be a so-called compulsory statutory remedy as considered by one of the learned single judge judgments. That the Income Tax Act itself says that a substantial question of law must be considered 260 capital A by a division bench. No problem at all. But what happens if there is no substantial question of law? Then what do we do? It is covered by a judgment of the Supreme Court. And my grievance before the tribunal is that this matter is fully and squarely covered. It's the effect to the order of the Supreme Court. That is all that I am begging and imploring you to do. And the tribunal says, yes, there is a mistake, but I will make this small change. But otherwise, according to me, if it is a loan taken for working capital purposes, Therefore, they apply the application test or the purpose test. And they completely ignore the basic test laid down by the Supreme Court in Mahindra and Mahindra, which is crediting the earlier year test. That is a crucial point. If that is understood and appreciated, there is nothing else in this case at all. And if the writ petition is not entertained and are relegated to other remedies, because the matter will still remain at large. And more than that, at some stage, 5 years, 6 years, 7 years from now, the matter will come back to this honorable court, and the matter will then have to be heard and decided again. So, in the exercise of discretion, whether this is at all that would be an appropriate thing in the public interest, in the interest of the revenue, and in the interest of the SSC, something which has to be very seriously examined. Now, let me come back to this. Now, in this case, in the Saurashtra Board Stock Exchange, let me give a little bit of background. The Income Tax Tribunal Milords gave a decision which was against the assessment. They are only giving the basic facts which are necessary to appreciate the point. It's a long order. Now, a few months later, jurisdictional High Court, the Gujarat High Court gave a judgment which decided the issue in principle in favor of the assessment. So the assessee filed a 254(2) application before the tribunal and said, now the law has been laid down and this is the jurisdictional High Court's judgment. You are bound by it sitting as a tribunal in the state of Gujarat. So please be good enough to rectify your order, which now demonstrates a mistake apparent from the record in the light of the judgment of the Gujarat High Court. So the tribunal allowed the 254(2) application and rectified its order and said, we are bound by the Gujarat High Court judgment. So we will now follow the Gujarat High Court judgment. And the earlier decision, which was against you, we now reverse. Following the Gujarat High Court judgment, which was the very opposite of the law declared earlier. Now, the revenue then files a writ petition. Very important. I'm not saying it concludes the matter, but what we are now hearing today is an argument which runs completely counter to the course of action which they have followed, not just in an isolated case, but in several cases. So the department files a writ petition against the 254(2) order. What does the High Court do? The High Court entertains the writ petition, disposes it of merits. Very important to understand. Not on the ground that you should go under capital A. And the High Court says, we are confirming the order of the appellate tribunal and we are therefore discussing the writ petition. Now that is very clear. If my lords will read only one paragraph of this judgment, which is at page 48. And let me complete it before I come to paragraph. The revenue then comes to the Supreme Court. Revenue does not raise any contention that the appeal is not maintainable. They only say this is a wrong order and the High Court should not have passed this order, etc. The Gujarat High Court judgment comes afterwards. What does the Supreme Court do? The Supreme Court thought that a writ petition could not or should not have been entertained, and that the only remedy available to the SSC is under 260 capital A. And there is no doubt the Supreme Court would accept that. Instead, what the Supreme Court did was exactly the same thing which the Gujarat High Court did, namely dispose of the matter of merits by saying that we hereby confirm as correct the order passed by the High Court, which affirmed the order passed by the appellate tribunal. Please see only that one paragraph, that is enough. So therefore, the issue of a writ petition not being maintainable at all against the 254(2) order was, in a real manner of speaking, directly before the Supreme Court. And this is quite recent, it is 2008-9. Now please see paragraph 48. For the foregoing reasons, the important thing to note is, revenue files the writ petition challenging the 254(2) order. And number two, both the High Court and the Supreme Court entertain the writ petition, deal with it and dispose it of on merits. And they say the tribunal's 254(2) order is a correct order. Therefore, the writ petition deserves to be dismissed. Please see paragraph 48. For the foregoing reasons, in our view, no case has been made out to interfere with the order passed by the tribunal, Ahmedabad, and confirmed by the High Court of Gujarat. Because they say that whenever the High Court declares the law, it applies even for past periods. There's a lengthy argument on whether the subsequent judgment of the Gujarat High Court would apply to past cases. So, the law is laid down, various learned textbooks are consulted, and then they say, in our system of law, when a court declares the law, it declares the law as it has always been. The court does not create law, the court finds the law as it has always been. So a High Court or a Supreme Court judgment is always declaratory of the law and therefore necessarily has retrospective effect and it applies even to past cases. Therefore, the order passed by the tribunal allowing the 242 application was a correct order, and the order passed by the High Court affirming the tribunal's order and dismissing the writ petition was a correct order on merits. Therefore, they come to the same conclusion. For the foregoing reasons, in our view, no case has been made out interfere with the order passed by the tribunal, Ahmedabad, and confirmed by the High Court of Gujarat. The appeal deserves to be dismissed and is accordingly dismissed, etc. Therefore, the important thing therefore to note is, revenue filed the writ petition, though that does not come to the matter at all. But both the Gujarat High Court and the Supreme Court entertained the writ petition and decided it on merits, even though it was a writ petition against a 242 order. Now, and finally, the SLC succeeded here. Now, let me place before my lords a very recent judgment of this. My lord, like to take it up tomorrow.
Now the tax roster days are only 2 days a week.
Since it's a backward matter and I'm here, special indulgence, I'll finish in half an hour now. Half an hour I mean. Yes, I request my lord, kindly accommodate me. Because I would like to start, but this will take a few minutes. I don't want to break it in between.
Can also appear through VC.
Yes, certainly. I'll try and do so.
Comfortable.
Yes.
But I want you to just think about it regarding whether you could either withdraw the appeal reserving liberty.
No, I understand.
You think about.
No, if I do that, this proceeding is dead. No.
Appeal.
No, I'm prepared to make a statement that I will withdraw the appeal. I'm prepared to make. I'll take instruction. I'll give it in writing. There is no purpose to be achieved in pursuing the earlier appeal. The earlier appeal is against the earlier order. That earlier order has been substantially changed. 4 paragraphs of that order have been surgically excised and thrown into the waste paper basket. And 4 new paras have been inserted. So it's a major transplant. It's a heart, lung, and brain transplant.
But you just address the situation.
Yes.
Suppose you file an SL, and then you file a review.
Yes.
And for whatever reason the SLP is not posted, doesn't get admitted.
Yes.
Meanwhile,
even no notice is issued. I remember the name now.
Correct.
Amal was state of Kerala. So volume 5 is.
That is a settled position.
Yeah, correct.
Now, before the admission of the SLP, the order is reviewed here before the High Court.
Yes.
What happens to the?
No, it has the whole consequences of the pending SLP. Pending SLP will be rendered infectious because if the order itself is set at naught, it can be done in a review. Or if the order is amended and the relief prayed for by the special leave petitioner is granted by the High Court and reviewed, why would it pursue the SLP? The SLP can be rendered infectious. There is no question of conflict or clash of jurisdictions. Let us be very clear. Remember this very clearly that till there is a merger, the High Court has full power to entertain a review and to decide it. To decide it on merits in such a manner that the relief prayed for in the SLP is granted, then why should the SLP be proceeded with? So if I succeed in this, because I will certainly not continue with my appeal and it will be meaningless. So the same situation would prevail. Please see,
I'll examine.
Let me elaborate a little on that.
Yes.
The dates are irrelevant and satisfy my lord on that. What my learned friend forgets me also. I would request him to.
The contention is there are parallel and independent remedies, and one will not come in the way of the other. Let us complete this.
Not that. In terms of the
No, that we'll see. We'll still considering. I've not made up my mind. I'm just hearing. One,
I have some problem on Wednesday and Thursday. Directly on Tuesday, this is a matter. Or Monday, whatever is there. At any time of the day, I'll finish in half an hour, 45 minutes. When it comes to the second Supreme Court judgment, it's even clearer. And again, a direct case where 254 order went against the revenue. Revenue filed a writ petition. That writ petition is dismissed. The matter is brought to the Supreme Court. And this time, the revenue succeeds. But it succeeds on merits, not on maintainability of the writ petition.
but
That is
there's,
the important thing to know.
but there's no direct judgment of the apex court on this.
Not in so many words, but then they're clearly proceeded on that basis. No, let me only put this. If the only remedy available to an SSC against a court to order is to see capital A. One would have expected the Supreme Court forward, but it's articulate that. One would have expected the revenue court to put forward such a contention.
But the judgment is an authority for what it states and
That is also there. That is also there.
not by deduction.
Not what can reasonably be said to be inferred from it.
Let us see.
Yeah, I understand. But then the question is clearly covered. Other judgments on substantial question of law, both of them say, yeah, it is covered by a judgment either of the High Court or the Supreme Court. And there is no substantial question.
What? No, but now what we can do, let him take his stand on merits also. Let him take his stand. Okay, so no. What I propose that if the next Wednesday and Thursday is not possible, we'll have it the week after that and we'll conclude it.
After that,
21st or 22nd. 21st or 22nd.
short holiday. Okay. Next week,
Okay, then we'll have it on 28th. By then you must find. Let us see. We'll have it on 28th. No, we'll have it on 28th. Let him finish his pleadings. We'll resume it. So see, there is one subtle question that is raised. Now, I'm just thinking aloud. I've not made up my mind. But there is a difference between maintainability and discretion to entertain. Now, the fact that a writ is maintainable is not in dispute. But whether in the when a substantive remedy is available, whether a writ should be entertained is a matter that has to be decided. Now, Shantaram's case appears to indicate that 226 is not remedy is not open when there is 260A appeal remedy. But that may not be. If you look at the other judgments of the apex court, including in GST, Justice Chandrachu's judgment in that.
My Lord's query is directly answered by a very recent judgment. In the case of Godrej Saraj, I hand over the judgment. I read only one paragraph. Many of my Lord's questions will be answered by that.
Even in tax statutes, apex court also has held that it's not and has carved out exceptions. In fact, in Assistant Commissioner of State Tax and others, versus Commercial Steel Limited, 2021, SEC Online, Supreme Court 884. In spite of statutory remedy under the GST Act, Apex Court says there are exceptions. And at para 11 says, what are the exceptions and how it will. And there it says that.
This is a much more detailed judgment. I've seen that judgment earlier. But this is always thoroughly, sorry. Always thoroughly, just in only one paragraph. Sorry for overstepping the time limit. This was a writ petition against a revisional proceeding which was initiated and an order passed in revision against which a full appeal lay under the VAT Act. So that was the objection which was raised to the writ, so identical objection. Please para 4. Before answering the questions, we feel the urge to say a few words on the exercise of writ powers conferred by Article 226 of the Constitution. Having come across certain orders passed by the High Courts, holding writ petitions as not maintainable. It's the very point which my Lord made. Not maintainable merely because the alternative remedy provided by the statutes has not been pursued by the parties desirous of invocation of the writ jurisdiction. The power to issue prerogative writs under Article 226 is plenary in nature. Any limitation on the exercise of such power must be traceable to the Constitution itself. Profitable references in this regard can be made to Article 9 and ordainments of other similarly worded articles in the Constitution, which specifically forbid writs. Article 226 does not in terms impose any limitation or restraint on the power exercise of power to issue writs. While it is true that exercise of writ powers, despite availability of a remedy under the very statute which has been invoked and has given rise to the action impugned in the writ petition, ought not to be made in a routine manner, yet the mere fact that the petitioner before the High Court in a given case has not pursued the alternative remedy available to him, it cannot be mechanically construed as a ground for its dismissal. It is axiomatic that the High Courts, bearing in mind the facts of each particular case, have a discretion whether to entertain a writ petition or not. One of the self-imposed restrictions on the exercise of power under Article 6 that has evolved through judicial precedents is that the High Court should normally not entertain a writ petition where an effective and efficacious alternative remedy is available. At the same time, it must be remembered that mere availability of an alternative remedy of appeal or revision, which the party invoking the jurisdiction of the High Court under Article 226 has not pursued, would not oust the jurisdiction of the High Court and render a writ petition not maintainable. In a long line of decisions, this court has made it clear that availability of an alternative remedy does not operate as an absolute bar to the maintainability of a writ petition, and that the rule which requires a party to pursue the alternative remedy provided by a statute is a rule of policy, convenience, and discretion rather than a rule of law. Though elementary, it needs to be restated that entertainability and maintainability of a writ petition are distinct concepts. The fine but real distinction between the two ought not to be lost sight of. The objection as to maintainability goes to the root of the matter, and if such objections are found to be of substance, the court would be rendered incapable of even receiving the list for adjudication. On the other hand, the question of explainability is entirely within the realm of discretion of the High Courts, writ remedy being discretionary. A writ remedy, despite being maintainable, may not be entertained by a High Court for very many reasons, or relief could even be refused to the petitioner, despite setting up a sound legal point. The grant of the claim relief would not further public interest. Hence, dismissal of a writ petition by a High Court on the ground the petitioner has not availed the alternative remedy without, however, examining whether an exceptional case has been laid out for such entertainment would not be proper. Now, here, the assessing officer felt that he was bound by an order passed by the tribunal, so he gave relief to the assessed. They initiated revision because they did not agree with the order of the appellate tribunal, even though the order of the appellate tribunal had not been challenged anywhere and had become final. So the High Court, so the Supreme Court finally says this is an appropriate case for a writ. Even though it was 100% open to you to raise the same issue in appeal. Why? Because the order passed by an appellate authority which has become final is binding. Therefore, it raises a question of jurisdiction. So the revisional authority acted without jurisdiction in ignoring the appellate order which had become final. And therefore, the writ petition should have been treated. And the ground which is given for rejecting it is bad in law. And therefore, we are setting aside the assessment order, we are setting aside the divisional proceedings, and we are setting aside the order of the High Court. We are lost in the High Court. The order of the High Court prevails. And for not see, we also say everything depends on whether you are raising a pure question of law or not. Please see para 8. That apart, you may also usefully refer to the decisions of this court reported in 1977 724, so and so. Indian Human Right. What appears on a plain reading of the former decision is that whether a certain item falls within an entry in a sales tax statute raises a pure question of law, and the investigation into facts is necessary. The High Court could entertain a writ petition in its discretion, even though the alternative remedy was not availed of, unless the exercise of the discretion is found to be unreasonable of powers, the court would not interfere. Now, therefore, the next sentence is very important. In the latter decision, this court found, without putting the appellant, that the issue raised by the appellant to be Christianly legal, requiring determination by the High Court, without putting the appellant into the mill of statutory appeals in the hierarchy. It's a Christianly legal issue. If it's a Christianly legal issue, then the writ should be entertained. What follows from the said decisions is that where the controversy is a purely legal one, and it does not involve disputed questions of fact, but only questions of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of alternative remedy being available. And this is then further reiterated in three or four subsequent paras, the same judgment, and various other judgments are also referred. Para 33, para 22, 33, and 38. Also, I would rely upon. Para 22. Where they rely on Kamalakshi Corporation. Now, in support of the proposition that in disposing of quasi-judicial issues before them, the revenue officers are bound by the decisions of the appellate authorities, and the principle of judicial discipline requires that the higher appellate authority decision should be followed. Here it was just an order of the tribunal. Here, in my case, we have a binding judgment of the Supreme Court, which holds the field, and no attempt whatsoever to cast any doubt on it. Then, para 33. While deciding the present decree of minority concern, the issue of assumption of jurisdiction by the revisional authority on the face of the unchallenged order of the tribunal dated 21st November 2001, and not with the merits of the decision either given by the tribunal or by the revisional authority. What stares at the face of the respondents is that the aforesaid decision of the tribunal, put in the order of the assessing authority, has attained finality. Once the issue stands finally concluded, the decision binds the state. A fortiori, the revisional authority. The decision of the tribunal may not be acceptable to the revisional authority, but that cannot furnish any ground to such authority to perceive that it is either not bound by the same or that it need not be followed. The para 38 is guidelines. There is nothing on record to justify either legality or sorry. The decision of the tribunal is binding even in the revisional authority. Such circumstances to grant the orders of the assessing authority as suffering from illegality and impropriety. Unjustified. In fact, they say it is the order of the revisional authority that suffers from illegality. So, I would also say one more thing. We are concerned with the legality of this order passed. Under 254 the tribunal's jurisdiction, is not a pre-ranging jurisdiction to go into the entire merits of the assessment. The tribunal has to see what is the mistake which is pointed out and correct the mistake. And if there is no mistake, then give cogent reasons for saying that there is no mistake. And my miscellaneous application, I will read it out of the next page. Speaks for itself. It says, these are the two tests laid down, principles laid down by Mahindra and Mahindra. Therefore, if you apply them to my case, it has to be that there can be no addition made in respect of this labor of loan at all. It's a simple point. The tribunal ignores it completely and just says, oh, you have taken the loan for working capital purposes. Whereas that is not the test laid down by Mahindra. There is nothing more to it at all. So the question of going into the merits of the assessment, going into the facts, permitting the director to buy a statement of objections, We are not now canvassing the merits of the original order. We are now looking at the tribunal's order. The tribunal, therefore, has either to say it is a mistake, or if it is not a mistake, then explain why it is not a mistake. Here is the order of the Supreme Court. But my Lord, see how the tribunal has dealt with it. Tribunal only says, but we have taken the note for working capital purposes. Therefore, to that extent, it is a revenue issue. But that is not the best way of it. So there is nothing more to it than this. So the question of expanding the field, going into pleadings, going into facts, does not arise. We are concerned with a very limited issue. The validity, legality, or otherwise of the order of the tribunal. Keeping this in mind, for Lords consider at earlier date so that there is no need to have expand the scope of the controversy. Could it be next week? I'll be very, very grateful.
Let us see, let him file for his satisfaction of his client and otherwise. The decision that we take, will take. Let us.
But say, if I can remove the 51st, I'll be grateful. I'll somehow I'll abandon my holiday. I'll be here on the 22nd. No, nothing. No, I just like.
So we'll have it. No, that's the word started. We'll have it on 28th. File what you have to by then. We'll decide. List the matter on 28th in further hearing list. It is the respondents to file their statement of objections by then positively after serving advance copy on the other side. But you may have to take some stand in writing relating to the pending.
Certain.
29th is a holiday.
Very much of that.
Your Honor, can I make a mention, Your Honor? Your Honor, serial number 61, it's a small matter, Your Honor.
No, just I'll have to rise. Wherever interim orders are in force, will stand extended. Dates,
Your Honor,
you can ask the court officer. Dates
Yes,
will
Your
be
Honor.
allotted, and dates will be allotted on the roster days.
Much obliged, Your Honor.
It is. You take dates.
Court officer, serial number 61.
Court Master serial number 51. Can we have it on 15th, sir? Court Master serial number 51 for 15th of June. And there is an interim order also. If you may please extend that.
Court officer.
2 ನಿಮಿಷ ವೆಯ್ಟ್ ಮಾಡಿ ಬರ್ತಾರೆ ಸರ್.
Monday ಅಲ್ಲ 14 ಎಲ್ಲ 47 to 14. ಯಾವುದು 21/6 next month ಕೊಡ್ತಾರೆ. ಬೇಡ ಸರ್. 21/6 ಅದು ಮೊದಲೇ ಬರ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದೀನಿ ಇಲ್ಲ ನಾನು. ಆಯ್ತು, ಇದು ಆಗ್ಬೇಕಲ್ಲ. ಗೊತ್ತಿಲ್ಲ ಆಗುತ್ತೆ ಮ್ಯಾಥಿಂಗ್ ಗ್ಯಾರಂಟಿ.
ಸರ್
ಜೊತೆಗೆ ನಿಮ್ಗೆ ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ ಜೊತೆಗೆ ಕನೆಕ್ಟೆಡ್ ಅಷ್ಟೇ. ಅದೇ ಒಂದು ಈಗ ನಾಲ್ಕು ಮ್ಯಾಟ್ರ್ ಒಟ್ಟಿಗೆ ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ ಅದ್ರಲ್ಲಿ. ಅದೇ ಹ್ಮ್ ಹೌದು ಎಲ್ಲ
Court officer.
Court officer serial number 51. Court officer serial number 51. Can we please list it for 15th?
ಸರ್ ಹೇಳಿ.
Officer serial number 61.
61 ಸರ್.
Next week
14/6
14/6 preliminary hearing ಅಲ್ಲಿ ಹಾಕಿ ಕೊಡಿ
ನಾವು ಹಾಕಕ್ಕಾಗಲ್ಲ, ಅವ್ರು ಹಾಕ್ತಾರೆ, ಟ್ರಾನ್ಸ್ಫರ್ ಆಗ್ತಾರೆ. ನೆಕ್ಸ್ಟ್
ಹೌದಾ?
Court officer serial number 47.
47
ಅಲ್ಲ
14/6
14/6
Okay, thank you.
47 14/6
Thank you.
61